Justices of the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business to do before this court will draw near and give their attendance, and they shall be heard.
Good morning, please be seated. In the matter of the application of Byron Brown versus Erie County Board of Elections.
Good morning, Mayor. Good morning. Sean Cooney on behalf of the appellant, India Walton. Good morning. The single most important thing I'd like to point out to the court is the table of cases in my reply brief at page 7. What's important about that table is that it demonstrates the utter lack of authority in this case to support the extraordinary claim here that this statewide deadline is unlawful and unconstitutional. There is simply no authority in any of the cases where a similar statute is struck down by any court. The U.S. Supreme Court does prohibit any state from enacting laws which make it difficult for independent candidates to reach the ballot. There's no doubt about that. What there is a lot of doubt, and what I find very hard to see here, is how that concern is implicated in this election.
If you could do this, it seemed like the ruling was predicated on Anderson's case from Ohio. That seemed to be the main basis. Why is that different here? What's different between your case and Anderson's case in Ohio?
The lower court referenced only Anderson. What the appropriate framework is the Anderson-Burdick framework, not specifically the Anderson rationale. What is different about the Anderson decision itself, as laid out on the table, is that all three critical factors are different. In Anderson, the deadline before the primary was 75 days, significantly longer than ours. The deadline from the general was 229 days, significantly longer than ours. And critically important, in Anderson, independent candidates had a simultaneous filing deadline to party candidates. The Anderson court referenced how discriminatory that is to an independent candidate. The other aspects of Anderson that are relied on so heavily simply don't apply to this particular candidate in this particular election. Anderson was a purportedly new emerging independent candidate who didn't have time at the deadline of March 1st, the March 20th deadline, to know that he wanted to run. As we put forth in our papers, Byron Brown was running, seeking the general election quite convincingly at the time of the state deadline.
Isn't one of the major differences between Anderson in this case is that Mr. Brown is running for local office, state mayor. And in Anderson, the Supreme Court placed great emphasis on the fact that Mr. Anderson was running for president and there were national interests. What happened in Ohio affected voters in all the other states. And that seemed to be a recurring theme in the majority's decision in Anderson.
You're absolutely right, Justice Lilling. In fact, what the Anderson described it as, a state has a uniquely different interest over an election wholly within its boundaries, a state and local election. The reason, of course, is that in a case like Anderson, there are other aspects of a national election, other states' primaries, national conventions that alter the interest of that state over governing that election. That is a tremendously important difference than what's happening on the New York State deadline in this election. Also, that same reasoning was applied in referenced in the Nader decisions that are in the briefing, where they recognize, like in Arizona, where no one had ever made the ballot as an independent candidate in Arizona's law ever, that has a different, is viewed differently because the state's interest over that election is different than it is over one like a local mayoral election. That's a critical difference.
Let me ask you this. The counsel for Mr. Brown points out that the deadline used to be 11 weeks before the general election until last year. Now it's 23. Before the 11, it was 7, and then before that it was 4 weeks. What is the rational basis for shortening it from, or from changing it from 11 to to 23. What's the basis there for the legislature to do that?
First, I would say that the deadline that exists at 23 weeks is been held constitutional under all these other cases. 161 days is less than a number of cases that have struck down. So before we even get to the interest, moving it to May is not unconstitutional. It's not a burden that's ever been struck down. The rationale, to answer your question specifically though, is that this is provided in the affidavit from the Board of Elections. It's in the legislative history. Of course, what happened in 2019 is New York State, for a number of interests, including complying with the MOVE Act, they unified primary between the federal and the state. When they unified that primary and moved it to June, they also enacted early voting. When they enacted early voting, as they described, the election law is a number of interdependent deadlines and rules. So when they picked up the whole calendar and moved it, they were also fostering the same interest that they used going back through all those prior histories, which is that the independent deadline before the primary justifies a number of other interests.
It's not necessary to have it more than 11 weeks. For example, it's not too late now, right? I think it might be too late Monday, but it's not too late now to get the ballot all straightened out. It wasn't necessary for these reasons, early voting, to move it from 11 to 23.
The requirement is not that it be necessary. It's that the legislature is entitled to some deference in their determination. The other interests that are implicated by moving it to May along with the whole calendar are things that the U.S. Supreme Court has recognized are valid interests, and that is to prevent excessive factionalism and allow for intra-party disputes in primaries to extend all the way to general elections. That's a valid interest. In fact, 47 other states have a much more significant burden than New York State on independent candidates. They have a total prohibition of sore losers. New York State is more liberal. We actually allow candidates like Byron Brown to make a determination of whether they want to proceed as an independent, as a party candidate, or both. So whether it was necessary or not doesn't mean that it's unconstitutional. In fact, New York State is so liberal, we allow them to do both. The other more liberal aspects of our scheme that promote independent ballot access, which are not disputed in this case at all, are we have very liberal signature requirements, only 750 for the entire city. That's mentioned in all these cases where these laws are struck down, that's a significant burden. Arizona, no one ever met that signature requirement. New York is so liberal here. We also don't have simultaneous filing deadlines, of course. So you could file 60 days after the party candidates are in the field. That's a valid liberal.
Right, in minor party candidates, they can petition later in the spring.
Correct.
Major party candidates got to go out from March 2nd to March 25th.
Correct.
In the cold.
In the cold. I think it begins in February. I think it's due in March. Correct.
Due in March. I thought it was March 2nd to March 25th, but in any event.
It's March 2nd this year. You're right, Your Honor. Excuse me. Some years it's February. It's very cold nonetheless.
For the non-major party candidates, they get the benefit of going out in April.
That's correct. Which not only the weather, but as the Anderson case mentions, it's when voters are more engaged. It's a significant advantage that the simultaneous deadline. In fact, the case in Wood, the decision in Wood, which distinguishes a prior decision in Cromer, it talks specifically about how when you give an independent candidate a deadline long after, like New York's, the deadline for party candidates, you're actually giving them an advantage. And I think which goes one step further to what's really being sought here, which goes back to your question about the move, is that having the deadline the reverse, which is what this case actually is seeking, meaning that the independent candidate wants preferential treatment. They don't not only want to be after the party designation, they want to be all the way after the primary in August.
Well, and that becomes an issue. As you see it, there's more of an advantage to have an earlier primary that allows parties to litigate and determination be made prior to the absentee ballots. You know, in the old rule, obviously, the Court of Appeals could decide a week before Election Day to add somebody to the ballot, and the absentees have been out. I think we recognize the ultimate practicality. What I find interesting here is that if this were to take place and somebody else were to file for the independent line, and somebody else were to file for the independent line, it is now necessary for the state to have another primary date to determine who's going to be the candidate on that line? I mean, that, to
Or
me,
many other lines.
Or any other line, but still, it does create a scenario that would result in potentially another taxpayer-funded primary date after one had already been done in June, and possibly now this would be an October primary date,
That is
if there was another candidate.
That was an incredibly important concern of the legislature. They actually talked about the cost savings, and I think the amicus brief mentions the burden that,
Yeah.
the proposed amicus brief, I should say, mentions that burden on all of these local boards of elections. The
Do you
point
have
I want
anything
to,
further then?
I'm sorry,
Do you
Jim?
have anything further?
The only thing that I would like to clarify, I think, is that the notion of preferential treatment, which goes to the interest that you mentioned, Justice Centra, it also goes to the closest they come to a deadline that was struck down was Hooks 1, which is a deadline that's more than twice as long away from the primary, right? But Hooks 2, it rejects the specific relief here, which is that the Byron Brown wanted to know the outcome of the primary before he ran. That is an impermissible request for preferential treatment under the Constitution. I would rely on my brief for the remaining points related to latches, their procedural things, and of course, I think what's really important is the state law failure to comply with the provision because of the related action in the federal court. That's a very important portion of my brief that I would ask you to take a close look at. Thank you.
Thank you.
Good morning, and may it please the court. I'm Brian Sells for the respondent. This court should affirm the judgment of the Supreme Court below because it was correct when it held that New York's early filing deadline for independent candidates is unconstitutional as applied to Mayor Byron Brown. The issue here is quite simple. New York's early filing deadline violates the First Amendment as outlined in Anderson versus Celebrezzi. Byron Brown, like John Anderson, is a genuine candidate who could command widespread support in the general election and has become the focal point for voters who are dissatisfied with the nominee of the Democratic Party, who will otherwise be the only candidate.
We understand, and you make those points very eloquently in the brief. Do you believe that the statute, the newly enacted statute, discriminates against the non-major party candidates? And if so, how does it treat them unfairly? How does it treat them more harshly than the candidates for the major parties?
Yes, Justice Lindley, the New York statute enacted in 2019 discriminates against independent candidates in precisely the way that the Supreme Court found Ohio's statute to discriminate, and that's on pages 490 to 494 of the Supreme Court's decision. It gives major parties the advantage of flexibility and independent candidates the correlative disadvantage of inflexibility.
Well, in
Anderson,
the deadline was March 30th. Here we're May 25th. Candidates for the major parties, if I'm not mistaken, they have 23 days to go get their petition signed. 23 days in March. The non-major party candidates have 42 days, and they get to go a little bit later in the spring. It sounds like that discriminates against the major party candidates in that one respect.
That's not how the Supreme Court saw it in Anderson versus Celebrezzi. And again, I would urge you to look at 790 to 794. The issue there was that major parties had more time in the campaign season to shift in position and respond to new issues. Independent candidates did not. And here we have that precise situation where the deadline for independent candidates is 28 days before the party primary. And no court, despite Mr. Cooney's table, and I'm happy to address those cases, no court has ever upheld a deadline in this kind of a challenge that is more than 1 day before the party primary. Just has not happened. Now let me go over those cases that Mr. Cooney mentioned, because he says that's the most important part of his brief. There are 5 cases that he identifies with the red highlight, and I can distinguish all 5 of those quite handily. The very
I
first
just want to
one.
make sure I understand what you just said. You said that there's no, if the deadline is before the major party primaries,
Yes.
those have been uniformly ruled unconstitutional.
In a challenge of this nature. And I'll explain what I mean by that. Mr. Cooney's table throws up cases involving very different kinds of challenges, okay? Some of them are challenges to a new party petition, don't even involve independent candidates. And the Supreme Court in Anderson says in footnote 12, look, new party stuff is different. And it is. The other thing is that many of the cases that he cites involve challenges to the actual effort of collecting the signatures by a certain time. The first step in Anderson is to identify the character and magnitude of the injury. That's a different injury than we're expressing here. Obviously, collecting 750 signatures in the city of Buffalo is not very difficult, right? We concede that. That's not our injury in the way that it was, say, in the Nader case. Our injury here is the premature cutting off of opportunity for a legitimate candidate around whom the voters have coalesced.
Well, for a candidate who has no intention of running on any party but the Democratic line, who then loses the primary unexpectedly and then wants to change course, that's what you're really saying. I mean, Mr. Brown could have easily complied with this deadline if he had any intention of running independent line from the beginning. There's 750, you get them from any registered voter, as long as they haven't signed before.
In that respect, Mayor Brown is no different than John Anderson. John Anderson.
But John Anderson did not run in the Ohio Republican primary.
John Anderson lost 24
Agreed.
Republican primaries.
He lost a lot of other primaries, came close in a lot of them, but in Ohio, we're talking about Ohio, he chose not to run in a Republican primary in Ohio. He wanted to go the other route. He was, now probably because it's a sore loser state, if he lost Republican primary, he's out, but the bottom line is in Ohio, he chose to go independent route.
Right.
In this case, Mr. Brown chose to go Democratic route, lost, and then after the deadline, well after the deadline, submits, and he goes in the other direction, which he could have gone from the beginning if he wanted to. Now, I'm not saying that necessarily precludes him from prevailing, but it's different factually than Mr. Anderson.
Well, I would respond by citing footnote 31 of the Anderson decision, because footnote 31 rejects that very justification that Mr. Cooney argued and that you're suggesting. New York does not have a sore loser statute, and footnote 31 says that it may not have a sore loser statute by happenstance, which is exactly what is happening here. So the Supreme Court considered that argument and rejected it.
Because
And
we have
again,
fusion voting here. We
Excuse
have
me?
fusion voting in New York, which is highly unusual, and that kind of goes against. But if sore loser statute, they've been upheld uniformly, correct? Sore loser statutes, meaning if you lose in a primary for a major party, you can't run any other line. Those are constitutional.
I'm not aware of a case that has struck them down. They are constitutional
I thought
under Storer, but they may
Storer,
not happen by happenstance, which is what happened here.
Storer said they were constitutional, and that's harsher than what we have here. Because in a sore loser statute, there's no alternative. Mr. Brown here had an alternative. He could have pursued two paths simultaneously. So if under Storer, the sore loser statutes are constitutional, it would seem tough to say that this statute, which is more favorable to independent candidates, would be stricken.
I disagree. I think the Supreme
I
Court,
assumed you would disagree.
well, the Supreme Court addressed that argument in footnote 31 of the Anderson
I will take
decision,
a
and I
look.
would commend that to you. Not
I'll take a
everyone.
look. I think what the general point is that we are not legislators. I think Anderson, by the way, it was 5-4 decision, would be decided differently today by today's U.S. Supreme Court, who doesn't, they proclaim not to want to legislate from the bench. But whether 11 weeks or 23 weeks or 10, those are legislative determinations that it's a very serious thing for a court to strike down a law. We're saying that the majority doesn't get its way. And now you've raised some constitutional claims, but it's not something that we do willy-nilly. And so there has to be a strong constitutional claim here, and you made a lot of good arguments, and we'll take a look at them to see if they raise to that level.
I would also, Justice Lindley, like to address your point with Mr. Cooney about the presidential versus mayoral nature of the races. And the circuit courts of appeals have generally rejected that distinction as being a major factor. And I would point the court to a case that's not cited in our briefs on that point, but it's Cowan versus Georgia Secretary of State, 960 F. 3rd at 1339, which I think gets it exactly correct. And that the court looks at that part of Anderson and says, look, the Supreme Court says that there's an extra thumb on the scale on step 2 or 3 of the Anderson test when a case involves the presidential election. It doesn't mean you get a free pass for mayors. And I think that's right here.
Okay, do you have anything further?
Happy to answer any more questions.
Any more questions? Thank you.
The Honorable John D. Centra presiding.
Morning, everyone. You may be seated. First case for oral argument we have today is 861 People v. Roth. Good morning, Counselor.
Good morning, Your Honor, and may it please the Court, Gary Muldoon for Anthony Roth. The main issue in this appeal is whether a county where none of the elements of the crime occurred and none of the parties lived has jurisdiction to prosecute the crime. This involves what's called injured forum jurisdiction under what the Court of Appeals has referred to as a rarely invoked statute. It's also called particular effect jurisdiction. Jurisdiction is said to be based on a custody order of Ontario County Family Court.
We recognize the fact that when we're dealing with the order of protection, that is an actual order from the court, which obviously is different than custodial interference, because that conduct took place outside the municipality, outside the county.
Yes, yes, Your Honor. And the concern that I have is what I would call the potentially the floodgate effect in a situation like this. Tropea v. Tropea was decided some 27 years ago, and that involves a parent moving out of state. And sometimes parents engage in self-help. And to allow every time that self-help occurs, inadvertently or advertently.
Well, and quite frankly, it doesn't even have to be a custody order in effect in order for this to take place. The custody order happens to be out there, but it has nothing to do with the custody order.
Correct, Your Honor.
You know what I'm saying? So we recognize the fact that with Tropea, we've had many, with you too, many relocation cases, but what we're dealing with here is something that took place. When you look at the statute has nothing to do with a crime has to occur as a result of an order. But once again, we recognize the fact that all of the conduct here, none of the elements that occurred in Ontario County, so obviously that's the strength of your argument that there's no ties pursuant to the statutory requirement under the CPL in order to bring your client back into the umbrella of Ontario County.
Your Honor, thank you. There's a historical contact, and that's the only kind of contact that occurs here. Custody orders, by their nature, can last for 18 years. Now, let me just move quickly to my second point, which was that the length of the order of protection. And I advised opposing counsel that I would be referencing a Fourth Department case that was recently decided, actually from Ontario County.
But ultimately, if you're successful on this, that order of protection has to be changed in any event.
That is correct.
If you're successful. We recognize that.
Very good. Thank you, Your Honor. I will submit on the rest of my arguments.
Hope we got you out in time. Morning, Counsel.
Good morning. May it please the court, Chris Eagleston in response. I would say that, well, this may be something that should be rarely invoked. In this case, it was properly invoked. Courts should have an interest in enforcing their orders. I don't know that there is anybody that should be more interested than those courts. And in that, it seems to me that the community's interest is invoked as well.
Well, Counselor, couldn't somebody just brought an application back in that court for holding him in contempt for violating that court order?
There's no question that they can.
Okay, and they didn't do it here?
That is, I don't know if they did, Judge. I don't believe that's clear from the record.
Obviously, we don't have it in front of us.
Correct.
Okay, so now we're dealing with a situation where the conduct took place outside the parameters or the confines of the county.
So was this extrajudicial, correct? I mean, the judge, in this case, issued an order, and we've made the argument, and I know that there's only a lower court case, a city court case, that has applied this directly to family court visitation orders, but it has been used. This rationale is the same. It goes to the efficacy of the judicial system, and that's the integrity of which the entire community is interested in. Happy to answer any questions.
Thank you, Counselor.
Thank you.
Okay. 855 People v. Was it Elan?
Good morning, Your Honors, and may it please the Court, Peter Banishak for Liam Elahan, and I'm appearing for Linda Campbell this morning. It seems to me that the key question here is whether Mr. Elahan's experience as a chef and his familiarity with the kitchen knife he possessed somehow precluded, as a matter of law, the finding that he acted negligently here as opposed to recklessly. And our position is that the trial court erred in relying on those facts, seemingly to the exclusion of the totality of the circumstances, in denying the lesser included offense charge for assault in the third degree.
The difference between reckless and, I mean, what we're talking about, really, what was his mental state? And whether he, really, the issue is whether there's any view of the evidence to justify a conclusion that he failed to perceive a risk of physical injury when he pulled his knife out. Okay, right?
Yes,
That's the question.
it is, Your Honor.
So this is, he's a chef, he's an experienced chef. He certainly knew what his knife could do, right?
Of course, and I'll let you finish, go ahead.
So that's okay. And he had just sharpened the knife, he had just left work.
If I may respectfully, because I think the people's brief points to the transcript that Mr. Elahan sharpened his knife. I don't think that's accurate, however. He testified that he used an 8,000 grain whetstone to clean his knife, to get the rust off of it, to remove any patina, but he specifically testified that that fine grain of a whetstone does not actually change the integrity of the knife and thus does not sharpen.
Does that really matter, though? In fact, I mean, he's a chef, he knows how a knife operates, we know the kind of knife it was. So, I mean, in essence, I think some of the factors that my colleague was just put out was mentioning that he was aware of all of those facts, that the instrument he was possessing had some dangerous propensities with it, or could be dangerous, and he even testified that. He said he held the knife close to him so he didn't hurt the potential victim in this case.
Judge, I can't disagree with that. I think, though, I would say two things. One is that training as a chef does not equate to training as a combatant. What would happen in a fight? He's not a soldier or something along those lines. And people generally understand that knives are sharp, so I'm not sure there's a huge difference between a chef knowing a knife is sharp and a regular person knowing that it's sharp. But more importantly, I think, is the facts of this case and how things unfold. He wasn't applying his experience as a chef in a vacuum without anything going on.
No, but he pulled his knife out when he knew that an altercation was imminent. And as Justice Sentra pointed out, he testified that he purposely held the knife closer to himself, so because he didn't want anyone to get hurt. So he knew what the knife could do. He knew that the knife could cause physical injury, and that's really what we're talking about.
Judge, I would ask the court to consider a few different factors here. One, he did pull out the knife, however, he did so with the intent to scare, not with the intent to use. Two, he was approached by
But that doesn't mean that he didn't know what the knife could still do.
I know, but I think that's the first step. And then I think that as the situation unfolds, he's approached by somebody who is undisputedly highly intoxicated. He does make an effort to tuck the knife into his belt so nobody is hurt.
But Counselor, doesn't your first statement kind of go against your position? Because you're saying what he did with the knife was he was conscious of what the knife could do, and that's why he did what he did. I mean, that's really what you said. He said that in his own words, in essence. Doesn't that bore down to the risk of, but consciously disregarding it? Doesn't that really bode for that?
I don't think so, Judge, for a few reasons. One is this is a tumultuous situation by all accounts.
Who approached who, though, Counsel? You just said he was approached.
When the evidence is viewed in the light most favorable to Mr. Elahan, he came upon the group. When the complainant saw him, the complainant approached him. That's Mr. Elahan's testimony, and I think it's also supported by the testimony of Sarah. I'm sorry?
The first time or the second time?
The second time.
Second time.
Right,
Yes.
Your client's testimony is highly implausible to the point of almost being incredible as a matter of law. But as you say, in assessing this issue, we have to believe him, as hard as that may be to do.
That is the standard, Judge. So I think there's an element of fear. Even if the complainant did not have a weapon himself, he did start to assault him. He hit him in the head. He threw him against a concrete wall. Mr. Elahan had just worked a 13-hour shift, so there's an element of
all of that is true. Really, the question, though, is there anything in this record to justify a conclusion that he failed to perceive the risk? I mean, that's what we're talking about. We're talking about criminal negligence.
I think when you take into consideration the fear that must have been in his mind, the exhaustion that he was under given the 13-hour shift he had worked, the speed with which this incident unfolded, the complainant said it was within the blink of an eye. All those things suggest that the jury had something to point to say, you know, given all that was going on in this tumultuous circumstance, at the moment this injury occurred, he may not have perceived that danger.
I think we have that.
And to the extent Your Honors disagree with our point one, we respectfully ask you to reduce Mr. Elahan's sentence. This is his very first felony conviction. His only other conviction is a 2009 DWAI. He's been employed his entire adult life, and the probation department recommended shock probation here, and under all those circumstances, I would respectfully submit that a 4-year state prison sentence was harsh and severe. Thank you.
Thank you, Counsel. Good morning.
Good morning, Your Honors. I was just going to point to the fact you've already pointed it out. I just don't see what risk could be here that he failed to perceive, rather than perceived it but disregarded. And I think the key testimony was, as you pointed out, he tucked the knife against his body because he was concerned that it could severely hurt himself. There's no risk that he failed to perceive. He did perceive the risk. So I just don't see how any view of the facts, even accepting it in the light most favorable to him, and accepting the facts in the light most favorable to him, I don't think we have to assume. I don't know that it's undisputed that the other male was highly intoxicated, the defendant was exhausted. I know there's those kinds of facts on the fringe, but I would submit to you there's no record support for the proposition that he failed to perceive a risk. With that, I'll rest on my papers.
Thank you.
Thank you.
856, People v. Focha. Morning, Counselor.
Good morning. May it please the court, Bridget Fields on behalf of LaShawn Falcha. This is a weapons possession case, as the court is well aware. I'd like to address the fact that the automobile presumption didn't apply in this case. It was error for the court. It's our position that it was error for the court to give the instruction, and that there was no evidence that would make that verdict legally sufficient based on any theory of possession. The automobile presumption applies when a weapon is found in the car. There are certainly cases that when there's continuous observation of the weapon.
Yeah, your argument is that it was the testimony that a bag was thrown out of the vehicle and maybe it was lost. It wasn't in the constant sight of the police officer the whole time. That gap in time alone takes it outside the automobile presumption.
Correct. There was a break in the chain of custody, and under the automobile presumption, that's essential, is my point. And that based on the evidence presented, that there wasn't sufficient evidence under any other theory of possession. There is no allegation of actual possession, and any either constructive possession or accessorial possession. There was testimony that the weapon was in the possession of 2 other occupants of the car. The allegations of when the weapon was fired, my client was seen driving and with 2 hands on the wheel with no access to the gun. So unless the court has any questions, I would rest on my brief for all the other issues.
Thank you. Good morning.
Good morning, Your Honors. Lisa Gray for the people. May it please the court. Well, the automobile presumption is certainly regarding possession of the firearm, not where it's found. And in this case, the defendant was driving the vehicle. He had passengers in his vehicle. He knew that gun was in the vehicle. He admitted that he knew it was in the car. It was brought into the car in a duffel bag. It was shown to the other occupants. There were 3 shots fired out of the front seat passenger. There was overwhelming evidence in this case that the defendant knew and acted in concert, jointly and constructively, to possess that firearm. That was used, actually, was fired out of the car. There was eyewitness testimony that corroborated the number of shots fired. There was forensic evidence that goes to just the overwhelming evidence in this case. In terms of the automobile presumption, again, the defendant made admissions that he knew the gun was in the car. It was certainly accessible to everybody who was seated in that vehicle that night. And unless there are any other questions from the panel, I would ask that the judgment of conviction be affirmed in all respects.
Thank you, counsel.
Thank you.
Have a good day. 857, People v. Santee Jr. Good morning, Counselor.
Morning. May it please the court, Tyler Bugden on behalf of Robert Santee. A traffic infraction followed by a blank stare from a motorist whose pants were unbuttoned does not give rise to a reasonable suspicion that motorist was armed and dangerous. This court, the Court of Appeals, have repeatedly advised that traffic infraction and innocuous behavior does not bear a logical connection to a reasonable suspicion that an individual is armed and dangerous. What does give rise to such a conclusion is evidence of a weapon or evidence that an individual is concealing something. But such evidence is lacking in this case.
What if there's reasonable suspicion not that the defendant or the suspect is armed and dangerous, but reasonable suspicion that the defendant has committed a crime, has drugs on him or her, or in the car? Does that allow a frisk?
No, not under Terry and not under the case law cited in the brief.
I agree with you, and that's what we, at best, that's what we had here. What the officer was, I don't think there was worried about a gun or a weapon of some sort. It was suspected drugs, and there was some reason to believe he had something going on there, but.
I mean, the strongest argument I think you have here is what the court's ultimate determination was. It found officer safety. And you're starting out with your argument is really that's what we have to focus on, or we're stuck with a consumption issue. So we look at it through that lens, through that view, and we look, is there anything that the officer testified to that gave rise to him being in fear or him having some fear for his safety? And we have to read the testimony, and if the officer doesn't appear to indicate any of that indicia that normally you would see accompanying a pat down because of officer safety. I mean, that's the strength of your argument. I mean, that's the way I look at it.
That's right. And moreover, Officer Talone did not testify to the fact that he thought that Mr. Santee was threatening him. There's no testimony from Officer Talone.
Well, all he said was that he took a wide angle or some type of language like that approach to the vehicle. That's the extent.
Officers do that as a matter of course. And, you know, at that point, he hadn't even observed Mr. Santee. So if that's the point, the moment in time when we analyze whether there is reasonable suspicion, all he's seen at that point was a traffic stop.
I think we have your argument.
Thank you.
Good morning.
Good morning, Your Honors, and may it please the Court. Jessica Carbone for the people. I want to touch briefly on something that Justice Lindley just pointed out. I respectfully, I have to disagree with the notion that the reason for pulling the defendant out of the vehicle was because he suspected drugs. The officer testified at the hearing. He literally had no idea what was going on in the vehicle. The testimony was that the defendant drove around for several city blocks.
So he didn't see any further movements by the defendant as he approached the vehicle. He didn't see the person reaching to his waistband. His waistband was open and unable to conceal anything there. It was 5 o'clock in the evening, so it's not like a late night concern, as you often see in these cases, 1 or 2 in the morning in a high crime area. This is 5 o'clock in the middle of the evening. So what caused the officer to have any concern about his safety?
You are correct, Your Honor. The officer did not see any movements within the vehicle such that would make him think that there was a weapon in the vehicle. And we don't contest that frisks that are done in this manner can be justified by an officer's suspicion that the defendant has a weapon. But that is not the sole basis, and that's our argument here.
But that was the basis that the court relied on.
Your Honor, I would submit that the court relied on the fact that the officer's testimony established he had a reasonable suspicion in general, and that was under Batista.
Reasonable suspicion of what?
Well, the language
Criminal
under,
activity in general.
correct, the language
Right,
under.
and let me just read you March. This is the case from 1967, which is still cited by the Court of Appeals. March, it says, when a vehicle is stopped, there are reasonable grounds for suspecting that the officer is in danger, which I don't think we have here, or there's probable cause, a reasonable suspicion, probable cause for believing that the offender is guilty of a crime other than a traffic infraction, then you can do a frisk. We don't have probable cause, so it comes down to reasonable suspicion that the officer is in danger. I don't see that here.
I respectfully, Your Honor, I think we had that. The defendant drove around for several city blocks, literally in a circle. And despite the fact that there was an officer behind him with his lights and sirens activated, he didn't pull over. When the police officer pulled his
How does
vehicle-
that establish that he's armed and dangerous?
It doesn't, Your Honor, but when the police officer pulled his vehicle next to the defendant's vehicle, indicating for the defendant to pull over, the defendant waved at him, which the officer found strange. When the defendant finally did pull over, he testified that he took this tactical standpoint, which I have to respectfully disagree with counsel, that it was a matter of course for him. He actually testified he doesn't usually do that. He testified he took a wider stance because he didn't want to take his eyes off the defendant. When he finally reached the defendant's vehicle, the defendant gave him a blank stare. He had his pants open. The officer tried to ask him for his basic name, license, registration. The defendant just stared at him. He tried to ask.
So this all establishes that perhaps his behavior was strange, but how does it establish that it's dangerous?
Well,
Or that he's armed? I'm just not following that.
I think, Your Honor, respectfully, under Batista, the standard there is that if there was testimony that the officer became suspicious based upon the facts that
Batista,
he...
isn't that the one with the bulletproof vest?
Yes, but
If the person has a bulletproof vest on and the officer sees the vest, I can understand that the officer might perceive that this person has a gun or be fearful for his safety. Here, what he perceived is the guy had his pants open and they were unbuckled, and his answer when he finally gave one was, I guess I was urinating.
Correct, Your Honor, and even that...
How does that put the officer in fear?
I think even that heightened the officer's senses, because the officer testified he didn't see anything within the vehicle or on the defendant's person.
And I think that goes to my colleague's questions. He didn't see anything. I think the problem you have here is that could it have been developed, would it have been better for you if the officer said the reason I got him out, based upon my observations at this, and this, I was concerned for my safety. Would you be in a much better position? Absolutely, whether it's successful or not. But once again, we're stuck to the hearing minutes. We have to look at the hearing minutes and see whether or not there's sufficient testimony in that hearing minutes that give rise for a situation of officer safety. That's really where I'm focused on, because there's no other probable cause for any other arrest here other than officer safety. And that's what really the court kind of hung its hat on. That's my view. So we'll take a look at that.
Thank you, Your Honor.
Okay, 859, People v. Pizarro. Good morning, Counsel.
Good morning, may it please the court. The first issue in this case is whether the initial knock on the door, which the police deemed a knock and talk, was permissible. The lower court applied DeBoer to the residence and determined that some suspicion was required for the knock.
Well, let me stop you there. The court may have applied DeBoer. I don't know if it's supported in state law that DeBoer needs to be applied. Anybody can knock on anyone's door. But as far as this argument goes, I think we are kind of boxed into that analysis because the court rendered its decision, and we obviously are bound by the Concepcion type of thing. So we can go forward with this argument with the analysis of level one, or the DeBoer analysis, strictly based upon the court's ruling. But I'm not so sure if this court didn't rule that way, we would require DeBoer. Because third department, and we take a look at Supreme Court cases, and we deal with those cases. DeBoer is really not applicable, but I want to let you know so we're on the same page.
Understood. To the extent that Concepcion makes this issue moot, then I should just go on to found.
No, it doesn't make more. What I'm saying, the conception, we're bound by analyzing this the way you want us to. But it's only because of the way the court decided, not by the.
I understand. So because the court applied DeBoer, this is a level 2 encounter. When Andre opened the door, the police told him what they were there for, and what they were there for was they suspected someone in the apartment was involved in their drug investigation. So that's an accusatory statement. That requires founded suspicion. The founded suspicion here was based on the fact that there was a Jeep that was on the same street as what the police believed was a drug house. It's well established in the case law that just simple presence in a high crime neighborhood doesn't reach any level of suspicion. And proximity to a drug house by itself does not reach founded suspicion.
Yeah, what you're saying is, in essence, from what the court had before, based upon the vehicle being registered to the defendant, drug activity at a house nearby, a male being in the vehicle, but nobody identified him as being the male in the vehicle. With all the facts they had before, does it rise to the level of reasonable suspicion for them to at least knock on the door at the house at all? Forget the accusatory, because now we get into a separate issue which you have regarding the consent search and the waiver.
Right, and it doesn't. Even if Andre Robles Pizarro had been the driver of that Jeep, it still didn't reach founded suspicion. The only evidence was there may have been some interaction between the driver and Rosario. But Detective Braun wasn't even sure if that happened at all. He wasn't testifying about his own observations, and he didn't give any evidence of anything beyond just innocuous behavior. There was only evidence that the Jeep was there once. The court's finding that it was there many times was not supported by the evidence. And as the court pointed out, he wasn't actually the driver. They were going and knocking on a door, and when somebody answered the door, they didn't know that that was the driver who had been there on Davis Street. So that's an even further step removed from cases where somebody's in the proximity of a drug house. So there was no founded suspicion to knock on the door, and certainly not to engage in that accusatory inquiry. To the extent that we get to the question of consent, the people did not meet their heavy burden of proving consent to enter. This was a person who does not speak English. So the defendant and the...
Well, let's clear this up. We're really dealing with here, at least from down below, the focal point down below is really the consent of the girlfriend and not the consent of the defendant. That's the way I read the hearing minutes. I mean, that's the focal point of whether or not she properly gave consent, either orally or in writing. Or are you disputing that? Is that the focal point we're looking at?
No, that we have to get past consent to enter before we can get to consent to search. So there was a lot more discussion below about the consent to search, and the consent to enter kind of got glossed over.
My understanding is the testimony is they were invited in, and his testimony is they weren't invited in. That's really, is it kind of a...
Well, Braun really didn't remember this conversation. He said, I don't recall what happened. So he did say he let us in, but he didn't say what words were used or what actions that they interpreted as consent to enter. He let us in is a conclusion, but the court needs to know, what did he say or what did he do that was consent to enter? Especially because of the language barrier, it's really important that we know what he said in what language. There was a Spanish-speaking officer right downstairs. Police chose not to get him. They instead had this interaction with somebody who could not understand them, with 4 or 5 officers, which was a coercive environment. He didn't know what they were saying, and we don't know what he said or did that they interpreted as consent to enter. The second part of this is that for Officer Santana, nobody testified there was any consent to enter. He just came in. He didn't even claim that Andre let him into the apartment. Even the respondent's brief doesn't address this. There's no legal reason why he should have been in the apartment. And he was the one who explained the waiver form to Lise Marie in Spanish. So his entry was essential to the consent to search, and he never should have been there. And then finally, to the extent this court gets all the way to consent to search, that was also not proven to be valid, because this was a highly coercive circumstance, and there was a number of police officers surrounding her, and the people just simply didn't meet their heavy burden of proving consent.
Thank you.
Thank you.
Good morning again.
Good morning again, Your Honors. May it please the court, Jessica Carbone for the people. I just want to touch on a few things, and then unless there are questions, I am prepared to rest on my brief. Just with regard to the testimony of, I'm sorry, not the testimony, but the comment of whether or not the second Spanish-speaking detective was let into the home. At that point, the defendant's girlfriend had already made admissions about the gun, and he was brought upstairs strictly because he was a Spanish-speaking defendant to make sure, detective, to make sure that she was being understood correctly and knew sort of what was going on. Other than that, Your Honors, I believe that the knock and talk was proper. The court below explicitly found that Detective Braun's testimony was credible and that the defendant's girlfriend's was not. He explicitly rejected her testimony.
Her argument is the fact that because he went down to the bore analysis, which, as I stated earlier, we're stuck with, whether or not their observations of the narcotics and the activity going on were sufficient enough to give rise to knock on the door originally.
Correct, Your Honor. I would submit they are. And I also would submit, well, we are obviously stuck with the record we have. I will note that the presiding judge at the suppression hearing, he didn't even really say he was making a finding pursuant to DeBauer. He said the common law right of inquiry, if you want to call it that. So I think that's arguable as well. But I do submit that the decision was well supported by the record. And unless there are any questions, I would rely on my brief.
Thank you.
Thank you.
860, People v. Woodward. Good morning, Counselor.
Good morning, Your Honors.
Appellant has submitted.
Yes, my opponent has submitted. Good morning, Your Honors. May it please the Court, James Gibbons for the people. Here we had overwhelming evidence that there was a cocaine conspiracy among the defendants. We had evidence that defendant personally participated in the conspiracy in general, as well as specifically in a transaction on June 6th.
What about the 330 motion that was denied without a hearing? That seems a little troubling to me.
I agree with you entirely, Your Honor, that the allegations of misconduct are troubling. Racial prejudice has no place in our society, and certainly not in a jury room. However, the court's decision to deny the 330 motion without a hearing is the only one that it could have reached based on the statute, which requires that the allegations and the affidavits themselves establish all of the facts necessary for relief. And here, these affidavits, again,
What was inadequate about the affidavits?
they don't claim that any of the jurors, they don't claim facts that would establish that any of the jurors' votes to convict were affected by a pre-existing prejudice. The allegations are of at least one overtly racist comment, but you have to contrast that with, for example, People v. Rivera, where there was a statement that was made before evidence was taken. Similarly overtly racist statement, but it was made before evidence was taken saying, I know that N-word was guilty.
Well, why does that matter? Here in the jury room, there are two jurors who submitted affidavits saying that there were other jurors in the room who seemed to have serious prejudices against the defendant, or defendants. In this case, there were more than one. We're only dealing with one here in this case, but how does that not at least create a question entitling the defendant to a hearing as to whether their prejudices affected his substantial rights?
Because it's not enough to just raise a question as to whether possibly some juror might have had a racial prejudice. You have to establish that at least one juror's verdict was affected by whatever pre-existing opinions they might have had.
So one of these two jurors who emailed about the racial prejudice in the jury room and the age, they had to go to the extent saying, I changed my vote because I was afraid of being, seen as not being racist? I don't understand what you mean by that.
No, Your Honor, and there's an example in People v. Estrella where, I'm sorry, the one example of what you described is People v. Estrella, where a juror herself or himself said, I guess I voted based on race. But Rivera was a situation where the statements themselves, the jurors testified that another juror, 3 jurors testified that a 4th juror had made a statement saying, I know this individual is guilty before evidence was taken. And that's certainly a basis upon which to infer that that particular juror's vote to convict was not based on the evidence, it was based on racial prejudice.
So there has to be that sort of an express statement?
It has to
What
be.
we have here isn't enough?
Well, that's correct, Your Honor. It doesn't necessarily have to be expressed, but it has to be enough that we can legitimately draw the inference. And what we have here, Your Honor, the most persuasive evidence that the verdict itself was not based on these prejudices is that although all of the defendants were African American, of the verdicts that were returned, there were 11 convictions and 9 acquittals, including one defendant, who again was African American, was acquitted on all counts. So without defending any of these allegedly offensive statements that were made, what we know is that they were not dispositive about the verdict that was returned. And none of the jurors who submitted affidavits claimed that any of the verdicts that were returned were actually based on racial prejudice rather than the evidence in the law.
Okay.
Unless there are any further questions, Your Honors, I respectfully rest on my brief.
Thank you, Counselor.
Thank you.
$862, People v. McGee.
Good morning, Your Honors.
Good morning, Counsel. We'll give you a few minutes to set up. 6 seconds. You may begin, Counsel.
Thank you, Your Honor. May it please the Court, Alan Williams for Mr. McGee. Unless the Court has any questions about point 3 of my brief, which addresses the law-based suppression arguments, I thought that I would submit on that and focus on points 1 and 2, which are respectively appeal waiver and weight of the evidence. With respect to the appeal waiver, first concerning the argument that there was no consideration for the waiver. Now, the people argue that if the lower court were not limiting its sentencing options, then it would have made no sense for the court to say, if you don't meet such and such conditions of the agreement, then I'll reserve the right to choose from the full range of sentencing options. But on the other hand, if the court were limiting its sentencing options, then it would have made no sense for the court to repeatedly avoid using the language of commitment and instead use the word willing or inclined when talking about the...
But there's no doubt that the court asked for the waiver itself, and that at one point the court said, when explaining why the court asked for the waiver, the court said, I'm requiring the waiver because of consideration on the sentence.
Yes, Your Honor.
Isn't that a direct thing, that the court was giving him consideration for
No,
the waiver?
sorry, Your Honor. I would respectfully submit that that presupposes the ground in controversy, inasmuch as the court may have thought that an inclination would have been consideration. The fact that we can call something consideration and it isn't necessarily. There was that famous contract case, Dougherty versus Salt, where the legal instrument itself said, if I remember correctly, that it was consideration, and the Court of Appeal said, well, no, just because you call it that doesn't mean it actually is, if I remember that correctly. So when the court was referring to it as consideration, the court may have believed that it was consideration, or it could have meant consideration in a more colloquial sense. Well, this is what I'm considering. I'm going to consider doing it. So we don't actually know that it is.
Why don't you spend your time on the second issue? Let's see if we can pass the waiver.
Oh, certainly, Your Honor. Thank you. So with respect to weight of the evidence, the points I would like to focus on, unless the court has questions about the specific application, are reviewability as of right and the specific standard. With respect to reviewability, the people argue that this is an issue that is subject to the preservation requirement. Now, if this court holds that it is, consider the paradox that that creates. If this argument that I'm making in point 2 of the brief had been made at the hearing court level, it still wouldn't present a question of law.
But the point you're making is weight of the evidence?
Yes, Your Honor.
On a suppression issue?
Sorry,
On a suppression issue? You're arguing weight of the evidence?
Yes, Your Honor, because the prosecution at a suppression hearing has the initial burden of showing that the officers acted lawfully, and until and unless that burden is carried, this is petinato, the defense's burden doesn't even come into play at all.
Right.
And
Usually we see weight of the evidence when we're talking about jury verdict, but really what you're saying, you're asserting credibility issues. You're raising credibility issues, that these two officers, Aquino and Hamilton's testimony was not credible in significant respects.
And the reason why I say that is that precedents have held that implicit in the fact that the people have the initial burden is that the evidence that they present in order to carry such burden must be credible. If the people don't present evidence that's credible in the first place, then there's no way that that evidence can carry their initial burden.
Right. Well, if we break it down a little bit, the officers claim, look, we're familiar with these officers. This is a case from 2014.
Yes.
These officers are well known to this court. Otherwise, to me, this would be a garden variety. We defer to the credibility determination of the trial court, but I'm familiar with many other cases with these two. So it gives me a little bit of pause. But what was the intrusion? They're following the guy, your guy on the street. They say he's looking at him and over his shoulder, but they didn't intrude on his liberty in any respect, did they?
Your Honor, I would respectfully submit that even if everything that I've said in point 3, the law-based point, is wrong, it doesn't even matter whether or not the record actually shows that there was an affirmative intrusion because of the fact that the defendant does not have any kind of burden at a suppression hearing unless and until the people have carried their burden of showing that whatever the police did, it was done lawfully. But that can only be done if the testimony of the officers was credible.
Okay, well, what was the first intrusion on your client's liberty under DeVore? When were they unlawfully approached or inquired or stopped or what have you?
Well, I would say that with respect, the first thing that they did improperly was that they were following him, continuing to as they saw him looking back. But I would say that that's only relevant with respect to point 3, because even if this court disagrees with me that the police have been shown to have done anything that violated any tier of DeVore at any stage of the encounter, even so, that would not be a basis for affirmance because of the fact, think of it this way, if the police testify at a suppression hearing, we did absolutely nothing, the defendant just walked right up to us and handed us a gun, something like that. If that testimony is not credible, then it doesn't matter that any of the testimony...
We recognize that. I mean, it appears to be in your brief, you go point by point showing the testimony, how they're inconsistent, correct?
That was one of the problems with it, yes.
And that goes to basically their lack of credibility because of the numerous inconsistencies within their testimony.
Yes, Your Honor. However, partly that and partly the other things, so since the court is already familiar with that, I do not wish to just repeat what was said there. But significantly, this court's analysis of that issue would be crucially determined by the 2 threshold issues, which are, is this an issue that is reviewable as of right at all, and if so, through what prism? Now, if this issue is considered a question of law, it's not really, and it can't be, it's not going to fit, because even if defense counsel had made this argument at the hearing, everything that I'm saying, it still would not be reviewable at the Court of Appeals, which has jurisdiction to review all issues of law, because it's a straight-up factual credibility issue, not incredible as a matter of law.
Can I just get back to one thing? Do you think it's the police need any degree of suspicion to follow and observe somebody?
If it's unobtrusive observation under existing precedents, it has been held that they do not require any level of suspicion, as I understand it.
Right, so here they, just on whim or caprice, could have followed these two or followed your client for no reason at all, just out of curiosity.
I would say, sorry.
And then your client rushes into the house allegedly. The officers then exit the vehicle. At that point, are you alleging his liberty was intruded upon when they went into the house?
I would submit that everything that they were doing, that the following, if there wasn't a level 1 violation, then it was a level 3 violation, that it was a pursuit. That is what I'm arguing. That's the police acted on.
They didn't even get out of their vehicle until he had already run into the house when they got out of their car.
Yes, that's true, Your Honor. He was cognizant of the fact that they were following him. They did not have any basis. He was reacting just in a sense of, well, perhaps not wanting to spend time in the company of officers, as very many people, for very valid reasons, would. But in any event, I would submit that the credibility problems are of such significance, particularly with these two officers. And I don't say that what we have here is a case of on-the-stand recantation. I mean, realistically, we're just never going to get that. We're never going to get anything of that level. But that is why it is so important, in order for credibility to be meaningfully assessed at the appellate level, that every single issue that comes up and all of them put together have to be very carefully assessed. And this is properly done under the same standard that is used for trials. A couple of considerations supporting this. The people are saying, well, I haven't found any cases that specifically add 2 + 2 = 4, that add Bleakley to suppression. The Bleakley case used civil case law to talk about the standard for criminal factual review. And the standards for civil and criminal factual review come from different statutes, but they're still the same. And when we talk about the standard for criminal review, it's all from one sentence in the same statute. It's the same language. And the Tankleff case from the Second Department applied broad review power to a 440 hearing. It just doesn't make any sense to say, okay, but when it comes to suppression hearings, we're going to have a different standard. And the language in the case law that talks about how, unless it's clearly wrong, it has to be affirmed, that's been disproved because it's not consistent with weight of the evidence review as explained in the Delamota case. And it's the same standard, regardless of whether we're talking about...
I think we understand that.
Oh, thank you, Your Honor.
Thank you very much.
Thank you.
Good morning, Counselor.
Good morning. Daniel Punch for the people. Your Honor, first, I don't believe we even get to the suppression issue because defendant validly waived his right to appeal. But if we did, regardless of the standard, the appellate courts still owe due deference to the judge in a suppression issue in credibility determinations. I'll leave it at that.
Thank you, Counselor. Thank you. 863 to 865, People v. Fox.
Good morning, Your Honors.
Good morning, Counselor.
Anthony Belt here for the appellant, Cody Fox. This is a plea case. We're alleging that there are numerous problems with Mr. Fox's guilty plea and that cumulatively they lead to the conclusion that either that his guilty plea should be held to be invalid or that his motion to withdraw his guilty plea should have been granted, or at a minimum that a hearing should have been ordered. I'd like to take a moment to run through the various issues that infected his plea. The first is that the defendant was mistakenly advised by the court that he could be sentenced as a second violent felony offender. To Mr. Sarando's credit, he has conceded that...
That's something that's going to be fixed, right?
Yeah, that can be fixed, and Mrs. Sarando has conceded that. However, at the time of the plea, he was operating under incorrect information. Number two is that the situation was that he had two different lawyers representing him on two different sets of charges at the same time. I don't really know why the court did that, but that can only be confusing.
That also works to the advantage of the defendant sometimes because it keeps the ball moving in the case, so to speak, especially in a county where it may not have the largest PD office. But in any event, I get your point with respect to the two lawyers. And then you were going to go into the conflict of interest in terms of...
Conflict of interest, that's another issue. Of the two different lawyers, first of all, the one that was more familiar with the case and that did the bulk of the work was not there at the time of the plea. The second lawyer was there, and that lawyer also had a conflict of interest because he actually, or his office, I should say, represented the co-defendant who was the driver and the owner of the car where the weapon was found.
So, Counsel, we recognize this. The deal and the plea bargain was struck way before it was struck before his arrival, the second attorney with the conflict. Second of all, the court went through asking him about the conflict if he wanted to waive it. Your argument is that he really didn't understand. The court never really explained to him what the conflict. That's really your bone of contention.
That really is, because number one, it was not explained to him at all of what the conflict was or why it might have some impact on his defense. And he also said at his sentencing, I didn't understand what a conflict of interest really even was. So, no, there was no substantive explanation of what is this conflict and why might it be a problem. Now, the judge himself also had a conflict of interest because the
And that had
judge...
been addressed before, as had the conflict with counsel, correct? Earlier in the case?
No, the judge did say at sentencing, I previously explained that to you, and then the defendant said, no, you didn't. And I looked at the record, I couldn't see anywhere where there was any kind of colloquy with the defendant about, well, I previously was your defense lawyer, do you have any problem with that? I didn't find anything. So I don't know what the judge was talking about. It might have been referring to some other case that he had with him in the past, I don't know. But on this particular case, there was no discussion of that.
And Mr. Bellatier, this may be too of a practical question. If you don't want to answer it, I get it. But is this a situation where maybe your client has to be careful what he wishes for? If we set aside the plea?
You know, I talked it over with him, obviously.
Okay, that's good.
You know, but yeah, I would say, what I would say about that is that he said also at the sentencing, this is not my gun. At least to the most serious charge, the gun. He said it was her car, it was in her car, I didn't possess it.
It's not terribly relevant to, well, it's not, whether he owned it isn't relevant to whether he possessed it, though.
Whether he said,
whether he bought it.
He said, I did not possess it. He also wrote a letter to the court where he said, at the time this gun was purchased, I was incarcerated. I could not have
But that
possibly.
has nothing to do with
No,
possession.
I guess I would say it would be circumstantial evidence. It's certainly, sure, you could later on gain possession of something that you didn't.
I have to tell you this, but most gun charges we get here is not from people that have purchased the guns.
Right, I'm sure, it's certainly not a defense to that. I'm just saying it's some evidence that.
It's circumstantial versus his direct admission that I'm guilty, that happened before that, right?
He said, yes, he
That's
put.
circumstantial, and then,
Yeah,
anyway, what else?
What else? Okay, so the first lawyer conducted, he obtained discovery, he filed motions, he conducted a suppression hearing, which I felt had merit, but it was not preserved, so I couldn't do anything about it. That issue was waived. The judge at the time said, well, I'll be giving you that decision in a couple of days. So why could they not wait and get the decision, talk it over with Mr. Fox, and then decide? There was no explanation whatsoever why that was done. And there was also the court decided to give him two different lawyers for two different charges. So if one of them was not there, why could you not adjourn it to another day? Because it says on the record that he's not available today. Why can't you say come back tomorrow? So the other thing is that I think there was substantial evidence of innocence because there was no DNA, there's no fingerprints, it's a constructive possession case. The other person owned the car, operated the car. And like I said, he also wrote this letter. The letter was never brought up by either lawyer at sentencing. The letter they wrote to the court saying, this is not my gun, I was in jail when it was bought. And in any case, the conflict operated whether or not the lawyer number two, we'll call him, was currently representing that co-defendant. Okay. Because that's a former client. You have a duty not to do something adverse to your former client. And arguably, incriminating her for possession of a weapon is exactly what he should have been doing in order to zealously represent the client. So there's so many problems. Each and every one of them, maybe in itself, is not determinative, but when you put it all together, at least a hearing should have been ordered on this motion to withdraw the guilty plea. And I've cited cases where this court has said when there is an issue, there should be a hearing. Thank you.
Thank you, Counsel. Good afternoon. Good morning, Counsel.
Good morning. John Sarando on behalf of Lewis County. First of all, we submit that the waiver of appeal was validly entered. And number two, going down, as far as the conflict is concerned, I think usually the court says, well, these are matters that should be brought up. They're not on the record, and they should be brought up on a 440 motion counsel has already filed a detailed 440 motion. We've already filed our response, and we're just waiting for a decision from the Lewis County Court on that 440 motion. Because I think it's important to consider that, starting with the crime itself, this was a weapon that was found underneath the passenger seat in a vehicle that the defendant was in as a passenger. So I think we're past that. He entered a plea, I think the court said, on the precipice of trial, if my memory is correct. So as far as counsel's indication of actual innocence or things like that, that's not present. And I think the problem we have is that the record doesn't show, this record doesn't show when the representation was concluded in regard to the co-defendant, which was almost, months before, but that's why the 440 would be irrelevant in regard to that.
Mr. Saranda?
Yes, Your Honor.
With respect to the conflict of interest that Mr. Bellatier addressed, was that part of the defendant's motion to withdraw his plea? Or is it unpreserved?
I think he said in there, I didn't know what a conflict was. He said it sometime, I didn't know what a conflict was. But we submit that the representation had concluded. And I think that is buttressed by what the court said at the time of the plea, where he said, I think you may have been precluded before, or there must have been a problem, the conflict before, but that has been resolved. The way that had been resolved was that co-defendant's case was concluded.
And Mr. Serrano, it looks to me like whether on that issue in part, when the defendant at the plea, as I recall, said no, with respect to the conflict, says no, there's no problem. I think the argument on the other side is whether or not that's enough. And so we got to look at that.
I think that is enough. And I think using this record, it needs to be exemplified by a 440 motion. Because usually when I'm standing over there, you tell me I need a 440 motion to exemplify those things. So I submit that that's the proper, and insofar as the discussion of the letter or counsel read the letter, the court knew what the letter contained, and I think as Justice Centrist said, indicated that the plea agreement had been agreed to prior to the other lawyer standing in. And as far as the sentence is concerned, he can still get the same sentence in times of year, just not as a second felony offender. And if there's no other questions, we'll rely on our brief.
Thank you, Counsel.
Thank you.
Both have a good day. 866, People v. Freeland.
Good morning, Your Honors. May it please the court, Danielle Chamberlain for Appellant Barbara Freeland. This is my first time before this court, so it's a privilege to be here.
Welcome.
Thank you. The Court of Appeals stated in Smith, subsequent to the Hurl hearing decision, that indigent defendants are guaranteed, our Constitution guarantees them the right to assign counsel. Yet Ms. Freeland, who I am representing through the 18B program, became indigent during her representation at trial, and she was denied the right to assign counsel to a public defender. The United States Supreme Court in Weaver v. Massachusetts in 2017 lays out 3 forms of structural error. It's a disjunctive test, and any one can result in reversal, but I submit respectfully that this matter fits within all 3 structural errors. The first error is when the right at issue is designed to protect the defendant from erroneous conviction, rather is not designed to protect the defendant from erroneous conviction, but rather from some other, or designed to protect some other interest. And the example was the fundamental legal principle that a defendant must be allowed to make his own choices about how to defend their liberty.
Let me stop you there, though. It seems like the question here, the defendant didn't want another lawyer. the lawyer, Mr. Sessler, who had been retained, wanted out because he wasn't getting paid. It's not like a lot of these situations we see where where a defendant complains about a lawyer and says, I want somebody else. This was, as I said, non-payment issue. And so that seems to be a little bit different. As a matter of fact, she got the lawyer she wanted all along, who she retained, and the judge wouldn't let the lawyer out.
Respectfully,
So it was the lawyer who was punished more so than the client.
And I would agree that the lawyer was a little bit punished here. But respectfully, I would have to disagree with the fact that Ms. Freeland never attempted to disengage with her trial counsel. She executed a consent to change on October 18th, a month before the scheduled trial. She attempted to engage with the public defender's office. They contacted the trial counsel and let him know that they were.
Counselor, when I looked at the record, it doesn't appear, at least when she was present during this the conversation that was transcribed, that she ever explicitly either joined in the attorney's application in the court or expressed some desire, as Justice Lindy pointed out, that she wanted different counsel. This is a different duck, and we're dealing with here because normally, as Justice Lindy said, you get someone who goes in and said, they're not coming to see me, they're not responsive, they haven't given me the paperwork. She seemed to be fine with the lawyer other than the fact of the fee arrangement.
Well, I would argue that she wasn't given the opportunity to join in the way that we would understand the procedure to work. The trial counsel didn't ask her, didn't engage with her at all.
She was in front of the judge, she could have said something.
She is a very mild-mannered lady, just putting that out there, but.
Well, this is what I think the better argument for you is. I don't think it carries a day, but she was forced to go to trial with a lawyer who wasn't getting paid, who may not have had his heart into it because he knew he wasn't going to get paid, and therefore he pled her out.
And then that's
more of the concern.
And that is exactly what I'm arguing here. I want to point out that this appeal has been pending since 2016. We did not receive the trial materials from trial counsel until July of 2020.
It was court ordered, we recognize.
And it was court ordered. So we did struggle a lot to get any sort of cooperation from trial counsel. And that just goes to show that, he wasn't in it. He was trying to assert
He did get a
attorney's
pretty good
name.
result. She didn't get any jail time, right? She got probation. She got, at the restitution, it was
I do believe she
way
served
lower than what.
She had weekends.
weekends. I do
Weekends,
believe
yeah.
that's true. But
And her restitution at the hearing, she got a fraction of what was claimed that was owed.
that is something that I wanted to mention. If you look at the decision in order from the grand jury minutes, 18 counts, 5 through 22 were all dismissed. And they had to do with transactions. The court states, and I believe it's around page 63 of the record, that there was no proof or no evidence at grand jury that the defendant knew that she was enjoined from any of those transactions. And yet when you go to the restitution decision in order, it's those 18 counts that she is ultimately forced to pay, and the people were unable to prove anything related to the other counts.
Okay, we'll take a look at that portion.
Okay, so I also want to take a second to talk about the statements my client made at sentencing. She unequivocally denied her guilt twice. She protested about the inability.
Counselor, before we get there, it's over here.
I know.
Before we get there, at the plea, and I just looked at the transcript a second ago or so, apparently there was a written memorandum outlining the key points of the plea prepared by the DA, reviewed by defense counsel, and the defense counsel specifically says, I have reviewed these points with my client. And then the court goes into the rather typical but thorough inquiry. Did you have enough time to discuss this with your lawyer, with your family? You're satisfied with your lawyer. You're not forced through. I mean, if you look at this plea, especially with the written memorandum that is apparently showed to the defendant prior to taking the plea and admitting to her guilt, don't we have to balance that pretty strongly against these claims that are made at sentencing? Only after, in the sentencing, there's detailed discussion of the restitution amount and of the order of protection that's going to be entered. It doesn't come up until the plea until she's given an opportunity to speak as she's entitled to at the time of sentencing. Given the record here, how could the court really think that that was anything other than disingenuous?
Well, I would like to point out the timing on the plea, and the respondent does focus on the plea a lot in their brief, and the plea was taken on only 11 days after trial counsel was denied their requested relief to withdraw. This wasn't finished for another over 2 years.
Yeah, it was a long time, 2 years, and in between, they had 4, 5, or 6 days of restitution
Right.
hearing, and the court rendered a decision, it was mentioned earlier, from the 70-some-odd thousand down to 4,200 and change.
Correct. So when you look at the totality of the circumstances here, when you look at the timing and you understand that this layperson who maybe isn't all that sophisticated, doesn't really understand the justice system, and she's trying to engage with the public defender. She's the exact reason why we have public defenders, so that a solo practitioner isn't forced to.
Yeah, but counsel, this is vote against your argument. I mean, the attorney goes in and gets the restitution knocked down by $68,000.
Which just goes to show how...
Well, I mean, your argument was he might not have had his heart into it and done his job, and yet he went in and was able to, not only that, up front, he originally got the indictment dismissed, didn't he?
18 of the 22 counts were dismissed.
And then at the back end, when he was forced to continue on it, he got $68,000 reduced from the $72,000 or $70,000 they requested.
And if you look at the restitution decision, that's more so based on a failure of the people to present the trust instrument, which...
Yeah, but somebody had to be, I mean, it didn't happen on its own, the attorney had to do it.
Yeah, and I'm not arguing that he wasn't there, that he, I'm not saying that he sat silently, but he certainly wasn't involved in the way that a public defender would have been. Somebody who wasn't financially invested in the length of this outcome. An indigent defendant who wants to go to trial is not going to keep the lights on at a solo practitioner's office. I would like to point out real quickly, the respondent at pages, I believe, 9 through 10 of their brief, they mischaracterize the law established by the Peck and Laurie cases, and they tried to limit the preservation requirement on the
What
plea.
is this comes down to, if I'm not mistaken, I think this is where you're going, does Lopez exception to the preservation requirement apply to statements made at sentencing? And you cite some cases, Beasley, that from 1969, it says it. That makes no sense whatsoever. But your client said, I didn't steal any money at the rest of I didn't steal his money. I didn't mishandle it. If that was said during the plea colloquy, of course, that's a Lopez exception. You don't have to move on that because there should be no plea, and if the plea was taken, it should be vacated. Question is, are we really going to apply that to statements at sentencing? If we did, it would give a defendant the unilateral option to withdraw a plea without even moving, just say, I'm innocent, and I want my plea back. That can't possibly be the law. It would make no sense whatsoever, but I guess your point is that that's what the Court of Appeals has said, and we got to follow it whether it makes sense or not.
I would say that that's what the Court of Appeals has said, and if you read Lopez, Peck, and Laurie all together, they basically stand for the fact that when a defendant has no practical ability to move to withdraw their plea or to vacate the plea, and I would say that this defendant had no practical ability here. She was telling the court, I'm innocent, I didn't do it. She wasn't getting any help from...
She could move to vacate the judgment.
Well, and I would argue that that was a failure of counsel, who at this point is more than 2 years since he's been paid, and he's stuck in here, and he's, that's just, at that point, he's been 2 years as he...
Okay, thank you.
All right, thank you.
Okay, 867, People v. Bishop.
Morning, Your Honors. David Abbotoy for Zachary Bishop. I have 3 points in my brief, but I'd really like to just focus my time on the first 2 of them. Initially, it's our position here that it was improper and not allowed for the court to enhance Mr. Bishop's sentence.
The defendant admitted that he violated the enhancement conditions, and at sentencing, he conceded that the court could impose the enhanced sentence.
I think that's the defense attorney's argument, and the defense attorney, I guess my response to that observation, Judge, is that although defense counsel may have conceded that Mr. Bishop committed those acts that were alleged against him, they were not relevant to the issue of sentencing because the judge was not entitled to enhance the sentence on the basis of those facts.
Yeah, why?
Because he only added those terms after the plea was over. And under this court's holding just here in Biaselli, those terms, and other cases in addition to Biaselli, those terms added after the plea did not become part of the sentencing agreement.
You're not saying he wasn't fully informed of the consequences of the penalty violation?
Well, yes, I am, in part, Judge, because although the judge lists these numerous conditions that are imposed on him after the plea, there is no real exploration with Mr. Bishop as to whether he understands the conditions, whether he accepts them, whether they've been negotiated as part of his plea.
Now, these conditions, they were imposed immediately after he entered the plea, at the same plea proceeding. So it wasn't, I mean, it's not like this happened 2 weeks later.
The plea is over and it's accepted, and beforehand, the only term that was placed on the record as being a condition of him gaining the sentence that he bargained for was just making his guilty plea. And I don't really think there's any debate about, what's on the record before he pleads guilty.
Maybe I missed something. I thought he also said that it's part of your condition on release for sentencing. It's part of your condition on release for sentencing, which is very common, that I'm imposing these conditions. You must do the following. And he agreed. Because the court could have simply revoked bail and put him in jail, not have to worry about those conditions.
I'm sorry, Judge.
So I don't see this as being in addition to the plea. I look at this also being part and parcel, being a condition of release.
If that's the case, Judge, then the most the sentencing judge or the lower court judge could have done was revoke bail in advance of sentence. But that's not what the court did here. What the court did was increase his sentence by almost 50% as a result of that. So although those may be common conditions that are put on people, pending their release, maybe even before their plea, you have to stay out of trouble, et cetera, or I'm going to take you in.
But the two problems I think I have to begin with is when that took place originally, there was no objection to it. And we know that, obviously, record. And then when they came in, when he violated it, there was no objection to the fact that these were illegally, unlawfully enhanced conditions. I mean, that's what, to me, is troubling
And here's how I think this court should address the lack of an objection or really a consent to these terms that Mr. Bishop did not, fully consent to. The consent or the lack of objection in the end is really just made by the defense attorney. But the defense attorney can't consent to a plea. He can't consent to the terms of a plea. So although he may have acknowledged that Mr. Bishop was arrested in violation of that instruction, the only way the court can enhance the sentence is if it was actually a legal part of the plea. And Judge Perodato, just to kind of go back to the question about timing here, the Biaselli case seems to be, first off, I would say, I don't think it matters how much time really elapses. The judge said we know what the deal was. The judge says he accepted the plea. I don't think timing matters. But Biaselli appears to be a case where immediately after this plea agreement goes through, the judge says he'll consider imposing a certain sentence, and then later on when the judge doesn't impose it, this court said, well, that sentencing promise that the court made after the person entered their plea was just not part of the bargain, and so it's not something that the defendant can ask the court to be held to. I think we really just kind of had the mirror image of Biaselli here, but the concept is the same. The concept is the same because if the thing that is supposed to bind the defendant or the judge to the sentencing process occurs after the plea colloquy is done and over with.
Counsel, as I grasp your position then, is a discussion of the enhancements should be done before the plea is accepted, in your opinion.
And
it's an integral part of the plea.
If it is, it absolutely should be tied to the sentencing promise that the court is making, and it should be conditioned as essentially part of the plea. Otherwise, it's tacked on to the end, and it appears to be...
Well, it does seem that it was tied to the sentencing promise. I mean, the court made it clear that, these are the conditions that are part of this promised sentence. It was tied to the promised sentence.
But Biaselli and Jenkins have essentially, I would argue, made a dividing line as to what things could be actually considered part of the plea, and what, in other words, what the defendant made his decision based upon, and what things were added afterwards without his consent or without kind of that benefit and bargain of exchange. In other words, something being offered and exchanged for consideration. When it's only...
Doesn't the lack of preservation kind of tie right into that argument?
I think not, Judge.
The fact that the defendant doesn't say anything, doesn't that seem to imply that he has no problem with these conditions?
I think if you conclude that the defendant had some duty at that point, I think what the court would actually be concluding is that the defense counsel, by not objecting to the thing, had consented to it. But there's clearly nothing on the record here saying that Mr. Bishop understood that the thing that the judge tacked on at the end was part of the bargain for exchange that had already been kind of sealed, or had definitely been sealed and accepted prior to this term being added. So since defense counsel couldn't accept the term on his behalf, and it's clear that Mr. Bishop didn't consent to it.
So at the end of the court's colloquy, when the defendant says, okay,
Right.
You're saying that did not demonstrate an understanding of everything the court had just said?
No, because the question that the court asks at the end, and it makes it extremely ambiguous, and I don't think this court can really assign kind of constitutional significance to it, is he says something like, and we'll adjourn sentencing for 2 weeks, okay? And Mr. Bishop says, okay.
And you're saying that's the only thing he understood?
Because it comes
That he
in
was
this,
acknowledging an understanding of?
he responded with the same word the judge left with was, we're going to adjourn for sentencing, okay, and he says okay. And typically when we see, enhancement terms added onto something, or when something is explained as being part of the plea, I mean, not only does it predate the actual statement by the defendant and the acceptance by the court, but the court is really going through and hashing out and making sure.
But I don't disagree with some of those things, except the problem here, though, is he says okay, and then later, after he violates, he agrees that he violated the conditions. So doesn't that kind of defeat this argument?
I
He
think-
didn't understand what was going on when he says, yes, I understand that I violated these conditions and that you're entitled to enhance the sentence.
Well, first off, I would say defense counsel said that, but my secondary response is this, Judge.
Defense counsel is all right, whatever.
But my secondary response is this, Judge. I'm sorry, I don't mean to frustrate you, but the second part of my response is this. This goes more directly towards the question you asked, I think. I believe that the question you're asking presumes that those conditions are actually part of the plea. So if defense counsel concedes, yes, those things occurred, that really only begs the question of whether or not that those facts are meaningful to the enhancement of the sentence. And they're only meaningful if they were actually part of the plea agreement to begin with.
Counselor, I think, why don't you get into your second, you want the harsh and excessive, you want to discuss?
Yes, I would just like the court to, and I know you will, take a look at the record overall. I believe the sentencing judge here got some of the factors backwards in terms of how it was going to judge Mr. Bishop's past, in terms of him being a victim of domestic violence at his home, in terms of whether his mental illness was something that the court should take into account.
I think your best argument is that the judge made it very clear he didn't like the promised sentence to begin with, and he was going to right that wrong here. In other words, he didn't calibrate it based on, he violated the plea agreement, what's that worth? It was, I didn't like what the deal was to begin with, and now I can just throw it out the window.
I think that's a valid point, Judge, and I think really lingering the back of all of these arguments I'm making on the first argument and the one I'm making now is that everyone sort of agreed that at the most, and the prosecutor certainly agreed, based on everything we know about Mr. Bishop, everything he did that, even if it was a violation of the plea agreement, the most he should have received was 1 additional year.
That's what the DA asked for. He asked for 1.
Yes, just 1. It's clear from the record that came right from the top, from the chief DA in the county. Everyone had examined these records and determined what the best outcome for this case was, not only for the victims who were involved, but for Mr. Bishop, based on his personal circumstances, with a full view of everything that had happened, including the serious injuries, and 12 was what the prosecution believed was the cap here. And if this court does anything, I think, 12 is an appropriate thing to do. Obviously, we're asking for something less than that, but I think that is an appropriate outcome if the court considers it. Thank you.
Good morning, Councilman.
Good morning, Your Honors. May it please the court, Josh Tonner on behalf of the people. I want to correct an error in my brief that was pointed out by Mr. Abitoy in reply in discussion regarding the sentence being harsh and excessive, or from our standpoint that it was an appropriate exercise of the court's discretion. I referred to the defendant as having been involved in 2 home invasion burglaries, and in going through the facts realized that in one of them it was, in the other one the victim was actually lured to the home of one of the co-defendants. I don't know that necessarily makes much of a difference, but it is a mistake on my part, and so I do want to correct that. With regard to...
So let's go right to the outlay warnings.
Yes. So, Judge, the answer to the question that you asked Mr. Abitoy is yes. Did counsel, and through counsel, the defendant expressly acknowledge that he had violated these warnings and agreed to them? And the answer is yes. Happened at 2 different appearances, both at the appearance when Mr. Bishop was ultimately returned on the bench warrant issued by the court, and then at sentencing. This case is not raised in the context of a 440 motion where we're complaining about the ineffective assistance of counsel. There's nothing in the record to indicate that the defendant didn't understand any of this, but the record does set forth that the defendant was aware of these conditions. I think the record shows that they're clearly and unequivocally given to the defendant.
He seems to quarrel with the timing of the outlay warnings, like that they, even though they were given at the same plea proceeding, that the warnings, the outlay warnings should have been given before.
And I'm sorry, Judge. I understood the argument that counsel was making in this case. I also, in brief, cited this court's decisions in Moore and Hines, which are older decisions, but indicating that if it's all part of the same plea proceeding, just the fact that the plea colloquy precedes the outlay warnings doesn't mean that the outlay warnings weren't properly given. And again, in this case, I think, and Justice Peridotto, you kind of hammered on it a little bit, is preservation should matter in a case like this where there's no objection to the warnings, there's no objection to the enhanced sentence, there's no motion to withdraw the guilty plea, there's no 440 motion. Everybody thought this was proper, and I would submit to the court because it was.
I'd like to be heard on harsh and excessive.
Judge, I think that certainly the strongest argument that counsel can make, in my opinion, is that our office only sought an additional year's enhancement of the sentence, which is accurate. There's nothing to dispute with that. It's a question of whether or not the court abused its discretion, or there's any extraordinary circumstances, I think, that would warrant the reduction. In this case, of course, the court has the authority to reduce a sentence. It's our position that the defendant has not demonstrated anything that would warrant a reduction. These are 2 violent crimes. The defendant, the arguments about his being a victim of domestic violence or having mental health issues, well, I don't necessarily dispute that. It comes entirely from the defendant himself. It's not
all of that was factored into the sentence promise when he got 11. So all these things you're talking about, he's violent, he did this, and that was factored in when you guys agreed to give him his sentence promise. Then the question is, okay, why should it be enhanced? He got arrested for DWI and didn't come to the hearing, so just going, how much is that worth? You guys initially said 1 year, it seems kind of reasonable. I don't know, let's take a look at it.
Again, Judge, I can't speak to that. The question, I think from our perspective, the greater issue is whether or not it should be reduced from the 11 that was originally agreed to, the 12 that was offered. I don't think that certainly that it should be.
Okay. Thank you, Counsel.
Thank you.
Thank you both. 869 Cook v. Corning Hospital. Morning, Counselor.
Good morning. May it please the court, Amanda Rossi on behalf of Dr. Singh. I think the key question here is whether the plaintiff's expert affidavit was sufficient to create an issue of fact. I submit to you that it was not, and that the expert affidavit was conclusory, speculative. It failed to address the expert opinions that were offered by Dr. Singh's expert, Dr. Reynolds, and it was therefore insufficient to defeat the summary judgment motion. Now, there are a number of issues that were addressed in our brief, but I'd like to talk specifically first about the claim that Dr. Singh should have ordered a colonoscopy within 24 hours of Mr. Cook's admission to the hospital. And I first want to point out that Dr. Singh did not even begin to take care of this patient until he was already 15 hours into his hospitalization. And within the first 3 hours, he does order a gastroenterology consult, and he speaks to the gastroenterologist, who is the specialist to determine how the colonoscopy should be done and when. He defers to that expert to begin the prep for...
I think when I looked at it, the focal point was it the telemetry, that the discontinuance of it. I think that's really where the focal point of why I looked at the expert affidavit on.
That certainly is something that was raised. And with respect to that, we have the plaintiff's expert saying simply that the telemetry should have been continued because of worsening lab results, which are not identified anywhere by the expert. He simply says that he doesn't point to anything. There's nothing in the chart that identifies any worsening lab results. He says something about the pulse and the oxygen being out of range. They are not. The chart itself has ranges, and it shows that those levels are within normal range. And the expert also says that it was Mr. Cook's medical history that required that, but there's no explanation offered as to why, when Mr. Cook was hemodynamically stable for 24 hours on the telemetry.
You see, he was, I don't disagree that he was perhaps hemodynamically stable, but there were changes, weren't there? The medical record did demonstrate hemodynamic changes before telemetry was discontinued.
The vitals were stable, and the actual telemetry monitors were stable prior to the discontinuation of it. And our expert opined that there was no reason for it to continue because of that. And with regard to causation...
And then in opposition, it's my understanding that the plaintiff's expert, with respect to your client, said that had telemetry been continued, it would have discovered that the hemodynamic and perhaps cardiac changes would have been discovered with the telemetry, right?
The expert does say that, but he or she doesn't offer any basis for why that would be the case. And this expert does not say what it would have shown, when it would have shown these changes, whatever they were.
Of course, the whole point of telemetry is to monitor those, whether there are changes, right?
That's true, but there's no indication of what should have been done if there were in fact changes. There's been no opinion offered as to what Dr. Singh could have done, should have done, and how that would have changed anything about what occurred here. This was a sudden...
Well, that's the proximate cause is the closer issue. I agree with you there.
Our expert has stated that this was a sudden, unpredictable heart attack, and there's been no opinion offered from the plaintiff as to what changes could have been determined and how it could have been prevented, even if there was telemetry and had shown anything.
Right, well, this is a case where we have experts clashing, and when it comes down to causation, that's almost always a question we send to trial. That's almost always for the trier of fact. And why should we not follow that general rule here on the issue of causation?
Because in this particular case, the expert opinion offered on causation as to the telemetry is entirely speculative and essentially not even offered.
It's speculative because there's no telemetry. If telemetry was there and it showed changes, then he could say this could have resulted or should have resulted in a change. If you take the person off telemetry and then you say, boy, everything after that's speculation, that just seems an unusual position to take.
Judge, it's our position that even so, the expert had to say what could have been done. What could Dr. Singh have done? What
So
test could
if-
he have ordered?
You say the expert should have said, well, if telemetry showed this, then they should have done this. But if telemetry showed this, they wouldn't have been aware of this. Well, that would be all speculation, and you'd be telling us they're just making up those numbers.
Judge, what's not offered here is any explanation or opinion as to how telemetry or changes shown on telemetry could have prevented the sudden heart attack. And that is the key failure by the plaintiff's expert. There's been no opinion offered as to what could have changed the ultimate outcome when the ultimate outcome is, as everyone agrees, a sudden heart attack.
Right, and I give you, it does seem odd, he wasn't being treated for his heart condition. He came in for something else.
That's correct as well.
He came in for rectal bleeding, these other things, and it does seem like there's, I think you might have a good argument at trial on causation. It's just a question of do you win as a matter of law on that.
We submit that the expert affidavit submitted by the plaintiff is insufficient to take this case to trial because no opinion has been offered as to how the ultimate outcome could have been changed.
Thank you.
Thank you, judges.
Good morning.
Hello, I'm Anthony Brighton. I represent Dr. Pearl, the Corning Hospital, and the Guthrie entity. I just want to make one remark on the telemetry issue, which I think is similar to the ICU admission issue that is raised with regard to Dr. Pearl. And where my colleague was talking about the failure of the plaintiff's expert to show how, I think you hit upon it, Judge Lindley. The plaintiff's expert, from my perspective, failed to tell me why. What is the rationale for ordering telemetry or admitting to ICU? Dr. Hayes, our expert, what I think the most important proposition is that this is a bleed the man has been brought into for a bleed that is expected to resolve on its own.
Well, I think the focus, I recognize that there's an argument that the decedent should have been admitted directly into ICU, but I think really the more compelling argument is that your client, Dr. Pearl, should have done a gastro consult earlier and kind of started the ball rolling with respect to the colonoscopy prep earlier. They kind of lost 24 hours, or at least, let me see, I'm not sure I have the timing right. Close to 24 hours before the prep started, maybe 18, but they lost a significant amount of time before he could have been subjected to a colonoscopy.
And I did want to address that. A colonoscopy is a diagnostic procedure.
Mm-hmm.
And we talk about the GI consult. If you look at the expert's affidavit, he says and or. GI and colonoscopy is basically the same issue to this plaintiff's expert. Colonoscopy is a diagnostic issue. It doesn't tell us what treatment the expert believes should have been performed in response to whatever the colonoscopy results were. Dr. Hayes is saying this is not a case where we are expecting to go to emergency surgery.
But couldn't that have been ruled out by a colonoscopy? The bleeding could be diverticulitis and small leakage from that, which is expected to heal on its own, or it could have been a major tear. And we don't know what was causing the bleeding, and shouldn't there have been an investigative tool to find out?
And shouldn't there have been an expert paragraph following the colonoscopy was needed paragraph that said, had a colonoscopy been performed, we would have probably found this or that? And that's what I'm asking. And that's the point I'm making about the colonoscopy. And maybe we end up going to trial on one issue, but maybe we can avoid going to trial on all of them. Thank you, Counsel.
Your Honor, may it please the court, Charlie Felgitano on behalf of the respondent. You made most of my points that I would make. I will point out the issue of causation. It's impossible to know. There's too many options. If a colonoscopy is not done, we could have said it could be this, and then they would say it's conclusory because there's 100 different options as to what could be found during a colonoscopy. There's 100 different ways somebody could become hemodynamically unstable. The key element is the autopsy. The autopsy doesn't say he just died from a sudden cardiac arrest. It was a result of a loss of blood volume in the heart or in the circular system that caused it. And that's in our expert's affidavit on paragraph 18 and 19. He explains that it was the continuous blood loss that occurred that was not, which would have been seen in some way. Exactly which way? Nobody knows because there was no telemetry.
So I guess I think the one of the main focus, one of the main arguments of the defendants is that there's a gap in the opinion of the expert. The expert, your expert, doesn't say how earlier detection may have prevented the death.
And I think in some ways that's hard to answer, Your Honor, because there was no monitoring to say it would have seen. We could have listed 100 things, but monitoring, we all know, on a telemetry is following the heart, is following the vitals. That's the purpose of it. And he does say if it was monitored, they would have seen changes on this. Exactly what? It's impossible to know because there was no monitoring. You're asking for expert to make, this is where it would be truly conclusory to say, I know I would have seen this. There's no doctor that could ever say, I know I would have seen this if this person was on
The
telemetry.
telemetry was discontinued, right.
Right, and so where is my expert going to go other than to say, it is my opinion within a reasonable degree of medical certainty, I would have seen, and more likely than not, would have seen changes, and these changes would have led to a reaction. What exactly? It's impossible to know because that's where the negligence lies. And if we're going to be held to that standard, then every case is going to be dismissed on causation because they're going to say when they don't do something, the defense is going to say, well, your expert didn't say we would have done this or that. You don't know necessarily in every occasion. And that would be an awful high standard that they're asking any expert to meet. So I think it is that key element is it's not just a cardiac event. It's a cardiac event because of the result of blood loss, which is why he came in the first place. And goes to the non-conclusory statements. He had coronary artery disease. He had this history. Exactly why he should be in the ICU and or telemetry. So.
Thank you, counsel.
Thank you.
$870 O'Harlow v. Cascades, Canada. Good afternoon, Counselor.
Good afternoon, Your Honor. I appease the court. My name is David Kelleher, and I represent Appellate Valmet, Inc. As the court is aware, we're here today in the denial of summary judgment on claims under the labor law, negligence, and product liability arising out of an accident at a construction site in Niagara Falls when a paper machine was being built and two seemingly inconsistent activities occurred at the same time and safety protocols were not followed. I'd like to start by explaining briefly the timeline of the 2 days before the accident because it bears directly on the issue of control under the labor law. On May 28th, 2 days before the accident, MRL, which was the plaintiff's employer, and La Framboise, which was together with the mechanical contractors, signed a transfer of care, custody, and control of this section of the machine over to Greenpack, the project owner. On the next morning, the 29th of May, the day before the accident, Greenpack signed that form, accepted care, custody, and control. And with that care, custody, and control of that section of the machine, authorized Valmet, my client, to go in and to begin testing the hydraulic components in the press section. At the same time, Greenpack, the owner, gave to Lotus Works, the commissioning manager, press section of the machine under the same transfer of care, custody, and control procedure. And Lotus Works held control of that section of the machine from May 29th to June 11th. And what control means from that includes the day of the accident, May 30th. What that control means, according to the project manager for Lotus Works, is at that point, I received total care, custody, and control of that particular system. It's up to my responsibility to take care of that system and maintain it safe through that period before I return it back to Greenpack. There's been a lot of argument in the briefs that Valmet had control of this section of the machine. It never had control of this machine. It was released by Greenpack to go in and do work.
Who turned the power on that day?
My client turned that power on.
And turning the power on resulted in what?
It resulted in hydraulic fluid going through the hydraulic system. And because...
And injuring plaintiff.
The plaintiff was injured because of rotation of a Unity box, yes.
It was powered by the hydraulics your client turned on.
Correct.
So your client didn't check whether someone was in the zone of danger when it turned the power on.
No, my client's responsibilities under the contract with Greenpack was strictly limited to testing the machine. Not responsibility for securing the area, not responsibility for supervising the installers, not responsible for coordinating the activity.
You believe your client could take action if they saw someone standing where they could be injured if the power is turned on? You're saying they could go ahead and turn the power on,
no,
and they have no liability?
My client has said if they saw somebody in the area, they would not have proceeded.
I thought the contract provided that your client would provide supervision of the installation.
Technical supervision.
Pardon me?
Technical supervision.
Technical
To
supervision?
advise Greenpack, not to oversee or supervise the installers. So my client was an advisor.
So when you supervise the installation, you don't have to supervise the installers?
No, in fact, it specifically says on page 3540 of the record, which is the contract, supplier shall have no responsibility for any installation work performed by the buyer or any of its contractors. It also says, beginning on page 3562 of the record, which lists the responsibilities of Greenpack, the owner, and Valmet, that general safety and security arrangements are the responsibility of Greenpack. Mechanical installation, work management, and workforce are the responsibility of Greenpack. The same for electrical, the same for pneumatics. So the way this project was divided up among a dozen contractors is that Greenpack had control of this section of the machine, and it told us what we could do and when we could do it. So
Therefore, you had no duty to check your own before going forward because they said it was okay?
Well, because that was the responsibility of other people on the project. So we didn't have a duty to go do that. We would have done it. If we had seen it, we wouldn't have commissioned. But the question before the court now is, did we have a duty to do that under the labor law or under a negligence standard? And we submit the answer to that is no, it's not a duty. It would have been nice, we would have done it if we saw it. It would have been more beneficial if we did it. On the question of duty, we submit that under the New York law, there was no duty.
There was no duty to look and see if anybody was in danger by your client's actions.
Correct, because that was the responsibility of other contractors. And if we had, so this machine is the size of a football field. This section of the machine is probably the size of a quarter of a football field. It's 3 stories high and it's 50 feet deep. So you can't see everything from where anyone's working. So you'd have to go and inspect the machine, decide that it's clear to do that, and begin to do your work. So Valmet's people had walkie-talkies on them. So on May 29th, they did test the upper level of the press, the highest level. When they did that, they put barrier tape up, they had spotters at that site, and they made sure no one was there. The next day, they're testing the next level down. They did the same thing. They had spotters at the site, they had barrier tape.
On the second level, not the third level.
Correct, because they finished the third level, and with the control in the commissioning portion of the project.
And when they finished the work there, did they turn off the power? Did they do the lockout? Or did they leave it open for the hydraulics there?
So those are separate issues, if I can address them both. Lockout is a procedure whereby the contractors who go in to do work are required to lock out the energy, both under the project rules and under OSHA. So that we needed the energy to flow in order to test the components. So the energy was on, and my client, it breaks in the morning, powered it, so it was not locked out. Hydraulic fluid was not locked out. It had been unlocked before we began, but it was shut off. But we didn't have locks, Greenpack had the locks. So on the day of the accident, we tested one set of hydraulic lines before the morning coffee break. So that meant we had the power on, and we tested the line, and it passed the test. Then there's a coffee break. Okay, so the hydraulic fluid in this suction machine, it's all connected. Every single hydraulic component will be, when you turn on the hydraulic system, they're all powered. That's why the rules are, if you come in as a contractor to work on a machine that's being commissioned, you need to lock it out and tag it out. And in this case, the MRL, plaintiff's employee, was cited by OSHA for failing to do that. That was their responsibility. Our responsibility was to make sure those mechanical portions of the machine function correctly. So with that, so the question is duty, right? We understand that under a lot of nice circumstances, we would have prevented that accident if we could have. But we had no duty to the plaintiff to go out and search the machine for workers under our contract with Greenpack or under the negligence standard. There's also claims of product liability in this case. We think that's like, this is not a finished product, it's a construction accident. And we haven't found a case, and no one in this case has cited a case, where there's been a product liability claim against a product that is not yet finished and not yet tested. So we think the product liability claims cannot stand. And in terms of the superseding cause, we believe that the employer had we know it had an internal communication failure. Their project manager knew the machine had to be locked out to go in and do the work. The mechanical supervisor knew it. They said it was delegated to the plaintiff's foreman. The plaintiff's foreman testified he didn't do it because he didn't know he had to. So had he locked it out, there would have been no accident. And MRL admits it was their responsibility to do that. Okay. With that, I'll submit the rest of my, on my brief.
Thank you, Counsel.
Good afternoon, Your Honors. Greg Pajak for the plaintiff, Seth O'Hara. Of course, Valmet had a duty here to not turn the machine on and make sure that when it did so, there wasn't somebody in it. I'm actually surprised to hear that Valmet is making the argument that they thought that they could simply, I guess with impunity, just turn the switch on regardless of whether anybody was in the machine. But the fact of the matter is that Valmet had both a contractual duty and a practical duty to make sure that it was safe to do their commissioning or their testing. The contract language
When
referred
you
to
say
by...
practical duty, you're talking about a legal duty?
No, I'm sorry, in practice, meaning, because what they had a contractual duty, because Your Honor referenced some of the contractual language that's referenced in my brief, but then in practice, what you didn't hear from Valmet was the fact that there was a morning meeting between SEPO, one of the Valmet representatives, my client's supervisor, and others, talking about the very work that my client was later directed to do, the punch list work.
And the punch list was on who's stationary and who did your client receive it from? Or your client's employer receive it from?
Metso, right. And so there's evidence that they created this punch list. It was discussed at this morning meeting. It was also discussed about whether or not the machine or the press section was locked out, and they were assured by SEPO that it was. At least that's the testimony of Mr. Musa, my client's immediate supervisor. So all of these issues were discussed, And then, yet, what ended up happening was they pushed the button, so to speak, with my client in it. I also think it's very important, since we were going through a timeline discussing what activities were done the day before, again, what you didn't hear was what happened with the ceramic installation the night before, and that's Valmet left open the hand hydraulic valve that I've attached. It's in the record, but I attach it to my brief because the record is quite voluminous, to say the least. But I think it's important to see there's a hand valve right there at the base of the Yulee box, which it left open. There's also testimony they made the decision themselves to leave it open. There's some testimony it was GreenPack that said to leave it open. Either way, they left it open. And they knew, and we just heard this morning, that they knew that that hydraulic power, when it went to the mid or nip level, would keep flowing up to the Yulee boxes. And that one little hand valve, there's been testimony from several people from Valmet that if that was in the off position, that hydraulic level can flow to that nip level all it wants, but it doesn't get to that Yulee box because that one little lever is off that they left on. They decided to leave it on during the overnight hours. They didn't. There was no reason it had to be on that morning. The nip level, you can shut that off and still do your commissioning in the nip level. So they by contract had a duty. In practice, they assumed a duty, certainly here, because they were the ones running the show during commissioning. While the TCCC form vested control with GreenPack, the testimony is that once that email was sent to to Valmet saying go ahead and commission, that was their problem. They did everything on their own with no further input. And if they had no duty to make sure that nobody was in the machine, why on the day before, when they were commissioning on the top level with the Yulee boxes, why did they put up barrier tape? Why did they have 2 spotters up there? Because they knew that they needed to make sure that nobody could go into the machine. Yet they're on the level just below. They know the hydraulic fluid can go all the way to the top, and they don't bother to walk up a set of stairs or put barrier tape up there to see who's there. I also think it's important to note, and this is in the record, that the press section is directly across from the control office, the hub, where they were pushing buttons. You can stand and look out that glass window and look up at the press section. Again, common sense says they have a duty here. Just touching briefly on the various labor law claims and the common law negligence, and I think by pushing the button, I'm going to get into Espinel now. Clearly, they launched a force or instrument of harm here. If that's not launching an instrument of harm, I guess I'm not sure what qualifies as launching. By pushing that button, it launched that Yulee box into action.
Well, and you couple the pushing the button with the kind of passive failures.
There were a lot of passive failures here. There was miscommunication.
Like leaving that valve open, yeah.
All over the place. I do want to touch briefly on the superseding intervening cause.
Can I just ask you a question about the products?
Sure.
The products cause of action. Their theory, Valmet's theory is kind of interesting, that the machine was an unfinished product.
That's what they're saying.
So if you could address that.
Sure. This is a unique situation, clearly. I admit that, and there certainly is no case directly on point dealing with this particular issue, but there's a first time for everything, as they say in the law. Maybe this will be it. My position is this on the finished product argument. The press section was finished. The construction part was over, and now it went to commissioning. This was a functional press section. We know it was functional because they were moving the parts. Hydraulic was flowing. Energy was flowing, electrical energy was flowing. This section was finished. Now, something else, this is 2 football fields long. At the other end, that part may not have been finished, but this was. But to the point on the products, the summary judgment dealing with products liability, they had the burden of showing that this is their motion. They had to show it was an unfinished product. I don't think they met their burden. Where's their expert affidavit? Where's anything in here to show as a matter of law that this was, quote, finished? Unfinished. And I think at least there's questions of fact dealing with the finished aspect of this motion, or of the machine in the press section. I do want to touch on superseding intervening cause briefly. Look, normally proximate cause is for the jury, but this doctrine has no application in this particular case, because what they're trying to say is it was that employer that didn't lock everything out, and therefore it cut off the causal connection as a matter of law. Again, I think there's questions of facts all over the place. But think about what they're saying here. They admit that they needed the energy to do their job, because you can't commission without energy. You have to have energy. Yet, they're trying to say that the employer is a superseding intervening cause because they didn't lock it out, which would have prevented them from doing their job in the first place. So what I'm saying is that that doctrine has no application here because energy was required. That's why I referred to it as a red herring, the whole lockout tagout. If this had been locked out, Valmet would have sat there and said, we can't do our job. So they needed the energy. The energy was there. So how can the failure to lock out, which would have prevented their work, be a superseding intervening cause? So I think the lower court got this right, and this court should affirm.
Thank you, Counselor.
Thank you.
Good afternoon, Counselor.
Good afternoon, Your Honors. David Katz from Smith-Silvic for La Framboise. I won't touch on a lot of...
Counsel, did you make a motion below?
We opposed. We did oppose Valmet's motion below. And the reason we did that is because this is really a case where the nub of it comes down to hitting that button. And so for us, to have Valmet out of the case excludes a whole realm of possibilities of fault surrounding why the button was pushed and how it was pushed.
So your position is that the court got it right and the Valmet is in for the trial?
Correct, Your Honor. And just briefly, I did want to touch on two quick points. One, there was some discussion of the lockout tagout, and I would just point the court to footnote 5 in our brief on page 9, which does discuss the fact that there is actually a dispute about the lockout tagout itself and what MRL had done to confirm that it had locked out and tagged out. But ultimately, as plaintiff's counsel did point out, Valmet knew it needed power, so one way or another, in order to do this, they did have to clear the locks in some way. And then the only other point I did want to touch on briefly is there was some discussion of OSHA, but as this court knows, OSHA is not relevant to labor law cases, and therefore, to the extent OSHA was brought up, it really shouldn't enter this analysis. And unless there's any specific questions, I would then rest on my brief.
Having none, thank you, Counsel.
Thank you, Your Honors.
Good afternoon, Counselor.
Good afternoon, Your Honors. May it please the Court, my name is Eric Bailey. I represent Cascades Canada, Greenpack Holding, Greenpack Bill, Normpack Industries, Mini Mill Technologies, and Jamestown Container Corporation. Hopefully that'll be the longest thing that I say to you today. I'm not going to go over all the things that have been said by counsel that have been pointed out correctly. What I would say are a few things. One, again, with the superseding intervening cause issue. The fact is, as was noted by Mr. Pajak, Kevin Musa testified to the fact that there was a morning meeting and that he was told by Valmet that, yes, go ahead and commission in the press section here. We'll be working in the real section. And the press section where you're going to be working is locked out. So yes, did they have a responsibility to make sure that it was okay to work there, to make sure that it was locked out and it was safe? Valmet answered those questions for them. Valmet told them that it was perfectly okay to work there. Now
Counsel,
Valmet...
your position is that the trial court got it right.
The trial court got that right, and that also
You didn't make a
goes...
motion below.
I'm sorry?
You didn't make a motion below.
Yes, we
You
did.
just opposed Valmet.
Correct, we opposed that.
I understand.
Thank you.
Thank you, Counsel. Have a nice day. 871, Misha v. JHF Management.
Good afternoon, Your Honors. May it please the court. My name is George Haddad. I'm with Legal Services of Central New York, and I'm here on behalf of the appellant, Mr. Mashup. The lower court in this case, Your Honors, made a decision denying appellant's motion for summary judgment, deciding that there was an issue of fact as it had to do with the appellant's complaint having to do with a wrongful eviction claim.
Well, it seems to me that that the moving papers contain isn't there a question whether he notified the defendants of his intention to abandon the premises? You know, there's it seems the record says that indicates that your client's sister advised that he was going to be terminating the tenancy and then later left a message that the plaintiff was not going to be vacating the apartment. The defendants deny that they ever received those calls. Doesn't that create a question of fact all by itself?
So, Your Honor, the question of fact arises, well, according to the respondents, the question of fact arises from that phone call that was allegedly made in the beginning of June 2016. And the respondents at the time that the phone call was made, they were not aware that it was the appellant's sister that was calling. It was an unverified call, voicemail that was left, notifying, according to respondents, notifying the respondents that the appellant was planning on vacating.
As I read the record, though, I think it's undisputed that your client basically acknowledged that that call was made on his behalf by his sister, a voicemail was made, and then he either changed his mind or it was equivocal in what he said the first time through the sister. But you agree, right, that the record reflects that he authorized the sister to make the first call?
So that was an authorization, Your Honor. That is correct. The question that comes up here, though, is at the time, the respondent was not aware who exactly it was, and that is in the record at 123 to 124 and 128.
Was the call that your client himself was going to leave, but wasn't his father on the lease as well?
His father was on the lease as well,
So
Your Honor.
how would the landlord, well, one party's leaving, they get a message, but the landlord's just going to assume that everybody's out?
That's our position as well, Your Honor, that's only if...
Without any keys being returned?
That's our position, Your Honor, and that...
Clothes being in there, a flat screen TV? I don't know, it just seems, but there are, it was not terribly unreasonable. The guy went there, the landlord went there and put a note up there and
Counsel, you have to try to
nobody...
keep your mask on.
Sorry. Yeah, Your Honor...
It did look like it was abandoned.
So-
It's just a question of whether you win as a matter of law, but I just don't understand, there is more than one tenant. It's just not your client.
Yeah, and my client was still in possession at that time, and that's the crux of this case, is if they're relying on an unverified call in the beginning of June for a month that my client is paid in rent. My client did pay June 2016's rent. So he is a legal client up until that end of that month. The respondent's position is at the end, once July 1st, 2016 hits, my client is a holdover tenant. Our position is at that point, if that is your take, you must give the holdover tenant, if you believe you got a legitimate abandonment notice and you received this call from an actual agent of the appellant, that you give the tenant due process. You give them their 30-day notice.
Unless your client has evidenced an intent to abandon the premises as of July 1, and isn't that the question of fact that needs to be resolved?
So if that was the only thing to look at in this case, Your Honor, I would agree. But what happens is subsequent to that call, number one, we did cite the Coleman case, which is a case down in the Bronx, which the court decided unverified calls from third parties are not sufficient on their own.
Mr. Haddad, I'm sorry to cut you off. You keep saying unverified. I thought you agreed with me that my reading of the record was correct. That is, there's no question your client authorized his sister somewhere mid to early June to call and say, I'm leaving or I may be leaving. Of course, whether it's I'm leaving or I may be leaving is a question of fact too, right?
That's correct, Your Honor, but the question is, what did the landlord know on July 1st, 2016? Not what did he know after the course of the litigation, right? Because that came out through litigation.
July 1st, your client hadn't paid the rent.
So, Your Honor, he paid through June 30th, and according to the lease, the rent is not considered late until the 5th of each month. So he is, at that point, not late on his rent.
You're not under the lease then, Mr. Haddad. It's clearly a month-to-month tenancy by operation of law, and it had been for years.
That's correct, Your Honor. Under the terms of the term of the lease, right, is going to be a month-to-month tenancy, but it's still abiding by the.
There was no lease in effect at the time that this all occurs, and it had been for years.
There was no term, there was no termed lease, but the actual rules that were under the actual lease itself that was signed back in 2014, those rules were still in effect, and that was the conduct of the parties. So what happens is July 1st hits, and respondent isn't completely sure.
Counsel, I hate to bother you, but we have a strict rule. We have to ask you not to argue if you can't keep it up.
Oh, I apologize, Your Honor. It just keeps slipping.
I don't, listen, these are tough times.
Yeah, no, I get it.
We've been saying this for,
Yeah. Sorry about that.
Mr. Haddad, you can at least say that I think the panel's showing a pretty good familiarity with the facts. I'll personally look at that myself and see whether or not the question of fact, whether you carried your burden as a matter of law.
Yes, I appreciate that, Your Honor. And we'd just like to point to the fact that on July 1st, the appellant's possessions are there. His furniture is there.
There's no, we notified, as he said, they're there, they put a sign on the door, they came in on the 5th and on the 7th, and that's when your client came back. We're familiar with the facts of the case.
Yes. Thank you, Your Honor. Rest of my brief. Thank you.
872 Morrow v. Bright House Life Insurance. Good afternoon, Counselor.
Good afternoon. May it please the court, Christopher Susing from Woodsmith, Henning and Berman for the appellants, Bright House Life Insurance Company, Metropolitan Life Insurance Company.
Let me help you with this, then. Maybe I can get you through. And correct me if I'm wrong, I may have misread it. This really boils down to when the statute starts to run.
Correct.
And there's an interpretation by the court that it really starts to run only upon a verdict of innocence or not guilty or whatever it may be. And you've recognized in your brief that determination of any criminal proceeding really applies to malicious prosecution, legal malpractice, but is inapplicable to the breach of contract, conversion, breach of duty, so on and so forth. And that's when, as we know, breach of contract, is time of the breach, we go through the whole thing, conversion, when it takes place, and all those dates clearly are outside of the statute of limitations.
Correct.
Aspect. That's, I understand the core of your argument. So the court should have dismissed the 4th, 5th, 6th, 10th causes of action as being untimely.
Exactly, Your Honor.
Okay, I mean, I just wanted to make sure I had it right, because it seemed to me it was pretty straightforward.
Yeah, your brief lays it out. Your brief lays it out very well.
Okay. Thank you, Your Honor. So exactly right. The Britt versus Legal Aid Society case, which appears the lower court relied on, should not be respectfully applicable to the remaining causes of action which have been brought against the appellants.
And this would ultimately bring the case to finality.
I'm sorry?
And this would bring the overall case to finality.
Yes, Your Honor, it would. Would you like me to further address that or the other substantive arguments?
Your brief is pretty solid.
Okay. Thank you, Your Honor.
Thank you.
Thank you.
873 Owens v. the State of New York. Afternoon, Counsel.
Good afternoon, Your Honors. May it please the court, my name is Elliot Shields. I represent the appellant, Phil Owens, in this case. This case involves an appeal of a dismissal of a claim under Section 8B of the Wrongful and Unjust Conviction Act in the Court of Claims. Section 8B4 creates
So let's just get right to the issues.
Yes, Your Honor.
The defendant now concedes that you meet the statutory prerequisites.
For standing, Your Honor, yes.
For standing, correct.
And we would request that any order written by this court explicitly state that, because there are no appellate decisions in this state that explicitly state that. So we appreciate that the state clarified that issue on this appeal. Section 8B4 itself creates a heightened pleading standard as opposed to other claims, and the reason for that is to make sure that frivolous claims.
But you feel you meet the heightened standard?
Correct. This claim is not frivolous. This
Well,
court-
and we're dealing with a 3211 motion here.
Correct.
So, okay.
Right, and our decision last time said that the video was strong evidence. I believe that's the word we used, that she might not have been there. It's kind of tough to dismiss something 3211 based on the wording of our decision in our last case. Now, and all you want is a chance to go to trial and your client have his day in court, which he's never really had a fair day in court. The first one was unfair, as we said, we reversed it. The second one got truncated, and now you want this to be litigated, and we have to view all the allegations as true, including her affidavit.
Correct, Judge Lynn.
Maybe but yeah, it's a minimal burden, 3211.
Correct, Judge. And we The main point that we wanted to raise with the court today was that is that when there is factual evidence submitted with a claim, all the fact inferences have to be drawn in favor of the claimant, which wasn't done in the court below and wasn't argued by
The court really
state.
made credibility findings.
Correct. And the reason that the court didn't issue an order with detailed factual findings was because it dismissed the claim based on its finding that a trial order of dismissal wasn't the equivalent of a jury acquittal. And so I think that at this point I would reserve the rest of my time.
We don't have rebuttal.
Oh, you don't have rebuttal? Okay. Well, I will rest.
We have your argument.
Thank you, Judge.
Good afternoon, Counselor.
Good afternoon.
It's okay.
3211 obviously is a standard that would be apply here, but there is also an additional standard, a more narrow, more focused standard, as the Court of Appeals recognized in Warney. In Warney, the Court of Appeals said that 8B, Court of Claims Act Section 8B4 represents a higher pleading standard than normally required to state a cause of action.
You don't think they met that standard?
No, I don't. And I think it's a strange case in that, in some ways, the claimant here laid bare much of the proof that might have come in at his trial. The claimant put in the trial transcript, which contained his ex-wife's, the testimony of Tara Owens. And Tara Owens, and it's undisputed, Tara Owens told the police that she was at this corner and she was shot at while she was driving a green Lexus. And she said that she told the police that it was her husband, the claimant here, who shot at her. Now, we know that her green Lexus was shot at because there's a bullet hole in the windshield and there was a casing, a 9mm casing in the
We don't know if she was in the car at the time or when it was shot. Look, I agree with you, there's evidence of guilt here. There's a lot of evidence of guilt here. But there's cause to question it as well. And we have a sworn affidavit from the woman who says it didn't happen, and I told the prosecutor, Mr. Gargan, it didn't happen, and we have that video.
Right.
Which shows in a very short period of time, she would have had to driven all around, change cars, get the kid out, and then be back at the scene to comport with her original story. So there's questions all over the place. I'm not saying that she's innocent, but it does seem like she's entitled, I'm not saying he's innocent, but I'm saying he's entitled to his day in court, it would seem like here.
Well, there is evidence in the record from an investigator who said that she couldn't have taken a certain route back to her mother's house and then come back in time to be shot at.
Well, and it's supported by video evidence. That's the thing. I think what we have to look at is whether on this pleading, the allegation in the pleading, which has some support by the video evidence, or with the video evidence, whether his innocence is a possibility. And if it is, I mean, that's really what it comes down to, right?
Absolutely, Your Honor. It comes down to whether or not this court looks at the allegations, but not just the allegations, but the exhibits. There's a lot of exhibits here.
Right. No, I agree.
And when you add up those exhibits, the question is, can you say that he's met the burden, the 8B4 burden, of stating facts sufficient for a court to find that that he's likely to succeed at trial in proving by clear and convincing evidence that he's innocent?
Is that the standard on a 3211 motion?
It's an 8B4 motion. It's an 8B4. Now, they work in conjunction. They're not supposed to make credibility determinations.
Right.
But you don't need to make a credibility determination. You don't need, the court below didn't.
Mr. Brady,
All you need to,
if her we have to assume that her affidavit is correct.
Yes.
If her affidavit is correct.
If her affidavit is correct, she either lied at the trial or she's lying in her affidavit.
But
let's look at her affidavit.
Wait a minute. If we take her affidavit as true, in conjunction with the video evidence, now that's a big if her affidavit is true. But if we have to accept that it is, that with the video evidence, which would show, even if she went in the direction you claim, she'd have to do all those things and come back to the scene in 104 seconds,
I
which is
don't-
still really tough to do.
I have no idea what direction she went in. I have no idea.
Okay, well,
But I
either
do
way,
know that her affidavit only says, it's carefully crafted, she doesn't disown anything she said beforehand. The only thing she disowns is that what she told the prosecutor. She said, I told the prosecutor that I couldn't identify him. So if we take that out of the equation, what she's saying is, well, it wasn't, she didn't see her husband shoot at her. But she's not saying she wasn't shot at. She's not saying that the person who shot at her wasn't driving the claimant's girlfriend's car. She's not saying the claimant's girlfriend's car, the police didn't find 4 spent shells from the claimant's girlfriend's car, which, by the way, happened to match the fire from the same gun as the 4 spent shells from the parking lot.
Counsel, excuse me. As my colleagues have pointed out, we recognize it. It's an interesting thing, as I understand the 3211 and how it's interplay with the statute. But once again, it appears that some of these conclusions reached by the court below, at least in my view of it, had to base it upon a credibility. Had to like discount something on a credibility. And that's what we have to look at it. If the court didn't, you're right. I mean, if it wasn't, there's no credibility interposed on the court's determination, and the court based upon the evidence it presented, then I think you're correct. But that's where I think, for me, where I'm going to.
I'll just leave you with this thought then, that what I think was demonstrated here was that the district attorney is not going to be able to prove guilt beyond a reasonable doubt. But I don't think the 8B4 standard was met. I don't think, if you read all those exhibits, that you can walk away and say, well, he's likely to succeed at trial in proving by clear and convincing evidence, which is what the court found. He's not that he's not likely to succeed at trial based upon all these exhibits. That, because he laid his case bare. I don't know why, but he did.
Worst thing that can happen from your perspective is he goes to trial and loses because he's got a really weak case.
Absolutely, absolutely. But unless you have any more questions.
Thank you, Counsel.
Thank you.
876 Rizzo v. Myers. Good afternoon, Counselor.
Good afternoon, Your Honors. May it please the Court. John Manier from Ralph Larigo's office on behalf of the appellants here today. The lower court erred in granting the lower court order for numerous reasons. The most important is that it failed to apply the proper legal standard for a preliminary injunction motion. And it is extraordinarily clear that that was the motion that was sought.
Mr. Manier, I've looked at this record a few times, and I just don't see where, on the face of the papers, that the plaintiff here was moving in any respect for a preliminary injunction. They don't cite the statute. They cite a different statute, the CPLR, in their order to show cause. The only provisional relief or temporary relief they got was to basically put a freeze on things. That's not the subject of the ultimate decision by the court. So I know you've got it phrased as a preliminary injunction, but the record just does not seem to support that. I mean, where is it in the record that they say we're moving for a preliminary injunction?
Respectfully, Your Honor, I disagree, and I'm going to point the court to the order to show cause that was submitted, or how this motion was brought before the lower court. It's page 72, it's the second part. In the, I believe it is the second ordered paragraph, it indicates that the respondents are enjoined, that they are temporarily restrained. That language falls squarely under CPLR 6301 and I believe 6312. When they are asking for that relief, this is the temporary relief that the lower court granted. It granted a TRO. A TRO is found in what is primarily before a preliminary injunction. You can't have TRO without a preliminary injunction. So that's the next step. It's procedurally set forth in the CPLR. That's the next step. So we go before the court grants this preliminary relief, the temporary relief, by granting this order to show cause. We submit papers in opposition to this. The court hears oral argument. After the oral argument, we're entitled to a hearing And we asked the court for a hearing on the injunction because the court granted this temporary relief.
But when the court opened the hearing, it had a very limited purpose. It wanted to check out, in particular, the signature on this document from December of whatever it was, 18, I think it was.
So-
I mean, it looked like a very limited purpose hearing, and I saw no mention whatsoever in that transcript that it was an injunction.
So,
Is there any?
let me, respectfully, Judge, let me just back up a little bit. We haven't even answered this lawsuit. This is all provisional, temporary, preliminary relief.
Did you ever object on that basis? Hey, Judge, we haven't answered. It looks like you're going down a summary judgment motion. Did you ever object?
Of course, we've had multiple conversations in chambers with the court, multiple conversations.
And I don't have that in the record, do I?
Not in the record, Your Honor, but I believe it's very clear from this motion that this is what the relief was brought, this is how it came about.
Mr. Manier, for my benefit, let's forget what procedural animal it is. Just, we can kind of go beyond that. I know that's how the brief is structured, and the other side has addressed that point too. But getting to sort of the merits of the thing, here's what seems to be most concerning to me, and I've got to get the page reference. Page 136 of the record. In addition to the fact that you've got this deed in lieu of foreclosure that's given at the time of the conveyance, that's reaffirmed at the time of the lease, but at page 136, if I recall correctly, the amendment, the escrow agreement, says this deed in lieu is being provided as additional security for the loan. In addition to every other facts and circumstances, didn't the court get that right, that this deed in lieu was given as additional security for the loan?
Respectfully, I disagree, and here's why. The lower court ruled that the deed in lieu was additional security for the loan, because if the court recalls from the record, at the sale, when the sale closed, the respondent was duly represented by counsel. The documents that were signed at closing were the note, the mortgage, and a deed in lieu of foreclosure. Now, I don't disagree, and I am not here to contest the respondent's brief in terms of all the remedies and all the case law that is in support of an improper deed in lieu of foreclosure. That's not what we have here, and it's important to note that we don't have that here. We have a subsequent agreement 20 months later that was re-acknowledged, that deed in lieu was re-acknowledged, the mortgage was re-acknowledged, the note was re-acknowledged. The respondent knew what she was signing at the time she signed that.
But the deed in lieu then, in December, was not properly filed because, again, this document would be void ab initio, and you don't even seem to contest that.
Well, here's how I'm going to address that. That's the RP 5217, if I'm correct in what the court's referencing in that document. All right, so the RP 5217, and the case law will support this, is that that's not necessary to file a deed. That document is not even a necessary legal document to file a deed. So, and essentially all that R5217 does is it puts on notice the local municipality of the new property owner and how the tax documents will be divided or sent to the property owner. It has nothing to do with the legality of a deed or the filing of a deed or who has notice of the deed. So,
Mr. Mayor, this would be my last question. Sure. You can quote me if I ask another one. But in terms of the practicalities, you still, even if we go along with what the Supreme Court judge did here, you still have a right to go foreclose in the ordinary, typical way, correct?
I believe we do, and that's a remedy that we certainly would assert in our answer. That would be a counterclaim in our answer, of course. But again, the way this was teed up was preliminary relief. We had the hearing and the court granted the ultimate relief in the case. Respectfully, this is, the lower court just simply got it wrong.
Yeah, and we recognize, I mean, we really have to look at, if this was teed up as a preliminary injunction, we have to view it in that sense, which obviously counsel has responded to in his brief, just as belt and suspenders type of an approach. But if we don't, then we have to go down the other avenue, how do we treat it? And that's a determination we'll have to make.
One further point I want to make with regard to our brief. The issue of property ownership is res judicata. There's certainly no dispute that it's res judicata. There was a properly teed up eviction action that came from a court of
Well, you see,
competent.
my problem is very simple. If you never really owned the property, if it's determined that you never owned it to begin with, you couldn't have brought an eviction proceeding.
I understand that.
So obviously, we recognize that if you're successful, you have to be if we determine that you never owned the property, or at the time didn't lawfully obtain it, lower court, then your position has to be different, because then you couldn't have gotten an eviction. Correct?
You're correct, if that's
And
how.
So that's how we recognize. We have to give from that stage, then if we do, I think your arguments are stronger with reference when you get to the eviction.
Agreed. However, it really falls on whether that RP 5217 negates the filing of a deed. I mean, or in other words, it makes it an invalid deed that's filed. I don't think that's certainly not the case, and that hasn't been raised. And when the deed in lieu was eventually filed, the appellants became the owners of the property. I mean, that's what happened. So we had a deed in lieu way back when the property initially closed. We have an agreement, a subsequent agreement, 20 months later. We have the respondent signing a lease, acknowledging that, hey, I'm no longer this property owner. The appellants filed the deed. They are the property owner. And once they filed the deed at that point in time, they were the true and correct owner of that property and commenced the eviction proceeding. At no time did the respondent ever raise at the eviction proceeding that she was an owner or there were ownership issues at that eviction proceeding. The transcript's in the record. It's extraordinarily clear. And I believe that the court has the rest of our arguments. If the court has any further questions, I'm happy to answer the questions.
Thank you, Counsel.
Thank you, Judge.
Good afternoon.
May it please the court. Good afternoon, Your Honors. Anthony Rupp on behalf of the plaintiff, Dawn Rizzo. Judge Kurt, I want to address something that you brought up with respect to that critical document at page 136 of the record, the deed in lieu, it's a strangely named thing, deed in lieu foreclosure agreement, escrow agreement is the name of it. And at the very last paragraph of it, it says that for that deed in lieu that had been previously signed back in 2017 when the property was first transacted to be filed, the following things had to take place. The note holder must send me a written notice of such default, requiring borrower to pay immediately the full amount of the principal, which has not been paid, and all of the interest that is owed. The date must be at least 10 days after the date on which the notice is delivered to me. And then there's an opportunity to cure. The testimony in the record before Judge Montour was that none of those things happened. They got the document signed, this deed in lieu of foreclosure agreement, escrow agreement, on December 1. They sent no further notices, and on December 4, they filed the deed in lieu. They never accelerated the debt. They never accelerated the principal or the interest. They never provided the notice. They never provided the cure period. So even if we ignore all of the standing law in New York that a deed in lieu of foreclosure is merely security for the loan if it's given at the time the property is transacted, if we ignored all of that law from the Court of Appeals on down, we still would have a violation of the very agreement that the respondent put in front of my client, not represented by counsel, and made her sign after he allegedly read it to her. He didn't follow any of the things that he said he would do, even in that agreement. So there's multiple reasons why the deed in lieu should never have been filed. And I disagree with counsel when he says that that tax form, which Judge Montour had honed in on as being important, wasn't important, because we cited 20 NYCRR 163.5, which says, no deed shall be recorded or accepted for recording by any recording officer unless the recording officer has received, with respect to every seller or transferor, an individual or estate, and then a form prescribed by the commissioner along with payment in full of the estimated tax due. So they couldn't file that document without the tax form. My client never signed the tax form. Her signature was forged. I think even the respondent conceded that, as he should, under oath in front of Judge Montour. So for multiple reasons, my client this property was stolen from her. I received this case from the Volunteer Lawyers Project to get this property back from her. And when we went before Judge Montour on that order to show cause, I had already signed a lis pendens to try to prevent them from flipping this property, which is what they wanted to do. But I also came in on order to show cause to stop the destruction of the property and to prevent the distribution and the destruction and the disposal of her personal contents. And as Mr. Muneer said, It was his side that requested the hearing. We went to hearing and we addressed these issues with full evidentiary proof, including exhibits, at the request of the respondent. The resulting decision is what we got. I think it restored the parties to the status quo ante that they should have been in, and allows them now to serve their answer and, as Judge Montour said, proceed with their foreclosure action. So no harm was done to anyone, and the process here, while maybe not the most perfect process ever invented, allowed the parties to go forward in a position where neither could do harm to the other. And so we've been in stasis since then because of COVID, but that's where things should be. They should serve their answer. We should proceed with the litigation. It's a 13-count complaint. This is just the very beginnings of it. This stabilized the case and restored the status quo ante so we can move forward. So I ask that you affirm.
Thank you, Counsel.
Thank you, Your Honors.
This court will stand in recess. Dine.
John, it's good to see you.